Mauer Management versus Sierra Lambert and Bridge Community Cafe.
Good morning, Your Honor. Ellis Reagan.
They are not checked in. You paid for second service. If you raise your right hand, you may proceed. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
All right, go ahead, sir.
I reviewed the ledger on this matter this morning. The rent, past due rent is 6625. Costs are 265.40 for a total of 6890.40.
Okay. Judgment to the plaintiff. That is by default. I have personal service against defendant 1. So judgment to the plaintiff for possession as to both parties. Redemption amount is in the amount requested with a writ to issue in 10 days. Money judgment in the same amount by default as to defendant 1, Lambert.
Thank you, Your Honor.
All right, thank you. Court calls case of Western Ridge Mobile Home Park versus Cindy Alvarado Lopez.
Good morning, Your Honor. For the record, Daniel Landman, P35797, appearing on behalf of the plaintiff. I did see the tenant earlier. There she is.
I think she's there.
Yes.
Hello, Miss Alvarado. Okay, what is
Good
plaintiff's
morning.
claim in this case?
Your Honor, plaintiff is claiming rent to retain of $2,303.43, as well as costs of $183 for a grand total of $2,486.43.
All right.
Mr. Plowman, right?
Yes.
Represented by Mr. Oswald. We have Mr. Harris from the prosecutor's office. We're here today for a pretrial. We had the opportunity to talk about the case a little bit in chambers. We have a try-by date of December the 10th. There's an offer of 4 to 5, right?
3 to 4. Yeah, that's correct.
Oh, 3 to 4, yeah. 2 to 3 mandatory, 12 months non-mandatory. Mr. Harris, what's our status?
Your Honor, Mr. Oswald approached me about maybe a different type of plea agreement. That's something that we'll consider it. I had indicated to him that if we can come back, I can explore that with him in more detail. So I think if we come back in about a week, we should have an answer as to whether we can work out a plea on this.
All right, are we waiving time today?
He did execute a time waiver. Essentially, the counteroffer was he'll agree to F3, no judicial, but amend the F2 to an F3 so he has more programming available in ODC.
So he would do an F3 with 36 months
Correct.
and no judicial release.
Correct.
Okay.
And he did execute a time waiver, so I'll set it quick, and hopefully we can do a plea at the next court date.
All right, we'll get it set next week then. Anything else? You understand all that, Mr. Plowman?
Yes.
All right, that's all.
Thank you.
Next is the case of the State of Ohio versus Kyle Clemens. This is case number 24. And 24 CR4. No, they're both the same. All right, present before the court is Mr. Clemens, represented by Mr. Mills. We have Mr. Harris from the prosecutor's office and Officer Martinez from probation. We are here today for a final violation hearing. Mr. Mills, does your client wish to have a contested hearing in this matter?
No, Your Honor. We're prepared to admit a violation to the original revocation and ask to be heard on continuing on ILC with the treatment recommendation.
Mr. Clemens, do you understand the rights that you're giving up by admitting to this violation?
Yes, Your Honor.
Is this what you want to do?
Yes, Your Honor.
Do you admit or do you deny that you violated the terms of your supervision?
Admit.
Based upon your admission, I find you have violated the terms of supervision. Mr. Harris, anything from the state?
No, Your Honor. Thank you.
Officer Martinez, what's the plan?
The plan would be that he would continue treatment at TCN to include level 2 and level 1 supportive housing. TCN is recommending that all aftercare be followed. And then he would continue to report to me. We'd start off probably once every 2 weeks, and then we would increase it from there depending on how he's doing at TCN.
Counsel?
Yes, Your Honor, I've talked to Kyle about that, and he's going to do that for you, Judge, and show you that he's committed to completing this program.
Anything you want to tell me, Mr. Clemens?
No, just I've learned my lesson. I'm just ready to get back to work and prove to you guys that I'm better. And I know I've made some mistakes along the way, but I mean, I just would like a chance to prove to you.
Continue on ILC or not?
I'd like to see him continue on ILC. Obviously, if there's additional violations, we would address it at that point. But I think that Kyle can be successful on ILC, and his biggest barrier really comes from him.
All right, I'm going to continue on intervention in lieu of conviction. We're going to modify the treatment plan to incorporate the recommendations of Officer Martinez, because it does seem like a solid plan. Here's the thing, Mr. Clemens, if you're going to be on the mental health docket, you do what Officer Martinez tells you to do. There's not any other options other than you going to jail, because somebody's on probation, somebody is on different kinds of supervision. I sort of invite other ideas on how we can approach things. I don't do that on Officer Martinez's docket. She knows better than you what to do. So she tells you to do something, you need to do it. All right?
Yes, sir.
Anything else?
No, Your Honor.
All right,
Thank you.
that's all.
Thank you.
Thank you.
So you need to go to,
Yes, I'll leave it.
speak, that's all.
All right, so Monin is.
Alvarado, how are you intending on paying this, ma'am?
Hello. Yes, good morning. I tend to pay next week because I start to work, and next week I receive my paycheck on Friday.
Okay. And you receive your paycheck next week on Friday?
Yes.
And how much are you gonna pay?
100, 1,400, 14,000, 1,400.
1,400. Okay,
Yes.
thank you. All right, so you're gonna pay 1,400 by next Friday, you say?
Yes.
All right, I'll grant the adjournment for that to occur and for you to seek any other relief. I'm gonna suggest that you call the plaintiff's attorney's office to work out payment of the balance, because you're still gonna have about 1,000 that is due. So 21st. All right, I will adjourn this matter out to November 21st, 2025 at what time? 2 p.m. That is, ma'am, that is an in-person hearing. So if everything's not paid, then you'll need to appear at the courthouse, okay?
Okay.
All right, thank you.
Okay. Thank you.
Thank you, Your Honor. Have a good weekend.
You do the same, sir. Northville Crossing versus Trudy Kopitz.
Good morning, Your Honor. Sydney Fontanella, P86316 for the plaintiff.
I don't have the tenants checked.
The tenants are not checked in. And Ms. Fontanella, the big news here was I come in the door, I'm running a little bit late, but I come in the door and the only thing my staff has to tell me is Sydney's here.
Well, happy Friday. I am here.
Yes. All right. All right. If you'd raise your right hand. You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do, Your Honor.
All right, go ahead.
Your Honor, there is rent due of $912.27, court costs of $190, for a total of $1,102.27. And I would request writ to issue in 10 days. This is a possession-only judgment, Your Honor.
All right, judgment to the plaintiff. That is by default for possession. Redemption amount is in the amount requested with the writ to issue in 10 days. And Northville Crossing versus Michael Powers and Jessica Lindau, and Gary Lindau.
Hello.
All right, I have Mr. Powers. Only one? Okay. All right, what is plaintiff's claim in this case?
Your Honor, this is a non-payment of rent case. I'm showing that there's rent due of $1,705.13, court costs of $302, for a total of $2,007.13 currently due.
All right. And Mr. Powers, how are you guys intending on getting that paid?
Well, Your Honor, Gary Lindo actually just passed by cancer on the 28th. We had his
Gary?
viewing on the
Okay.
Yeah, we had his viewing on the 2nd and his funeral on the 3rd. Unfortunately, his daughter and I missed a little bit of work to help with the funeral and arrangements. If you can give us till the 28th, I can have that full amount paid.
Okay, let's do it this way. And my condolences on your loss.
Thank you, sir.
What I will do is I will adjourn this out 1 week to the 21st, 2025 at noon. All right. And what I'm going to suggest that you do, sir, is contact the plaintiff's attorney's office and see if they can arrange for a conditional dismissal or something that will allow you to get to that date on that.
Okay.
Mr. Powers, my phone number's on all of the paperwork. It's a 248 number. I work for Pallets Law.
Okay, and just ask for you, ma'am.
Yep. So I'll give you my direct extension. It's 175.
175. Thank you, ma'am. I'll
So
call you.
just give me a call sometime next week and we can figure it out.
Thank you, ma'am. Any help would be, we will have it paid by the 28th. Like I said, it was just an inconvenience of just bad things.
Yeah, we'll work. Just give me a call.
Thank you.
You did what you had to do, right?
Yes, sir.
All right, very good. We'll see you next week, sir. Thank you. Court does call the case of Northville Crossing versus Tony Rogers. Hello, Miss Rogers. Oh, she's trying to figure out. There she goes. All right. Okay, what is the plaintiff's claim in this case?
Your Honor, this is a non-payment of rent case. There's rent due of $1,820.50, court costs of $190, for a total of $2,010.50 currently due.
All right. And Ms. Rogers, how are you intending on getting that paid?
I spoke with Bobby the other day when I made a partial payment, and I let her know that I will be paying it this week, either Tuesday or Wednesday.
Okay, so you're gonna get the entire balance in sometime next week?
Yes.
Okay, so here's what I'll do. I'll indicate in my file that you're gonna pay the balance, I'll say by the 12th or 13th. Okay, well, not,
Can
that
you give
was
me
silly.
what the current
No, by
remaining
the,
balance is?
go ahead, I'm sorry.
Is there any way that the attorney, does she have what the current remaining balance is, or should I just call Bobby again?
Hold on, let me pull it up really quick. I just have to double check your ledger, Miss Rogers, and see if the one that I have shows the partial payment that you made. So give me just a second. Okay, Miss Rogers, mine does not reflect the partial payment, so call Bobby at the office and she'll give you a correct amount. As to
All
how
right,
much.
thank you.
And then just so I know, how much did you pay?
$1,035.
Okay, thank you.
Okay, all right, very good. All right, so what I will do is I will adjourn this out to November 21st, 2025 at 12 p.m. It's at noon. That's an in-person hearing, ma'am. But if you have everything paid and you confirm that everything is paid, they will likely dismiss the case, so you don't need to appear.
Okay, thank you so much.
All right, thank you. Have a great weekend.
You too.
And then I have Northville Crossing versus Nicholas Buckland, Northville versus Stephen Kilgore, and Northville versus Cassandra Studer. Those matters are dismissed on plaintiff's motion without prejudice.
Thank you, Your Honor. I think it resolves this morning's docket, but I'll see you back at 3 o'clock.
Oh, okay, fantastic. All right, thank you. Have a
Yep.
great morning.
You too.
Homestead Commons versus Alyssa Gray.
Good morning, Your Honor. Brent Tinger for plaintiff.
Good morning.
Good morning, Miss Gray. All right, what is plaintiff's claim in this case?
Right now, I have outstanding rent at $3,664.90. There is cost of $175, putting the grand total at $3,839.90.
All right. Miss Gray, how are you intending on getting that paid?
I have an appointment with the VA over on Hogback. I don't know what you will call it, with Miss Audrika Jacobs. I have an appointment Tuesday at 2:00. And this had to be pushed out because she was at a conference. She was out last week. So she has me coming in next Tuesday. And
Okay, and that's with
only,
the VA.
Yes. And that's for partial balance. That's for the 2,800, and I have the remaining.
Okay, gotcha. So you have some, and then the VA, you're hoping will cover the other one. Are you a veteran, ma'am?
Yes, ma'am. Yes, sir.
You are? Okay. Yes. Which branch?
Air Force.
Okay. Well, I don't know about those guys that like to fly, but whatever. Okay. Okay. So I just like to note that in the file, ma'am. All right. So what I'll do is I'll let that appointment take place. I will adjourn this out to November 21st, 2025 at 2 p.m. Okay, that's an in-person hearing. So you'll have to come down to the court unless everything is paid.
Okay.
I might suggest that the portion that you have, that you might want to pay that to the landlord in any event. Okay. All right. And I say that only because why don't you wait till after your appointment with the VA to see how much they will pay? Because they may, depending on which one you get, they may cover more than what you're expecting.
Oh, okay.
Okay. And that may get you, what you have now may get you well into December. They may pay through November. You follow what I'm getting at?
I do. Yes, I hear you.
Okay. Yes. Fantastic.
Okay.
All right. Thank you.
All right. Bye-bye.
Bye-bye. Orchard Grove versus Carol Eberly.
Brent Tinger for plaintiff.
Carol Eberly, not present. If you raise your right hand to be sworn, you may proceed. Do you solemnly swear affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
All right, go ahead, sir.
At this time, we would ask for a default possession only judgment. I have outstanding rent at $769.65, cost at $193, for a redemptive total of $962.65.
Excuse me, Judge, this is Patrice from Orchard Grove. I didn't get a chance to talk to you, attorney. I received another $700 yesterday, late yesterday, from Miss Everly. She emailed me, and this morning when I came in, there was an email. She had a CT scan this morning, but she had dropped it off, so I put it in, and I'm going to upload it to the file.
So basically, the 700 she owes a little bit plus cost, correct?
Yeah. So
did she go ahead? Did she say when she was going to have that?
She has the 700. She dropped it off in the Dropbox last night. She had
right, but
paid, on the 4th 800. So she's paid up. She's a little bit more.
She's paid in full.
Yes, for October.
Through October, but then she owes November.
Yeah, she owes. It still shows $245.65.
Got it. But she paid the 700. I'll tell you what I'm going to do, given what's been said, that she had a CAT scan and a CT scan this morning, as well as the payment that she made. I'm going to adjourn this out, see if she can get the balance paid and resolve it. So I'm going to adjourn it out rather than allow the judgment to November 21st, 2025 at 2 p.m. Okay.
Thank you.
No objection. Thank you, Judge.
Thank you. Orchard Grove versus Georgia Lahire.
Brent, take a complaint.
And Nicole Lahire and Robert Rudy. Who's here? Nicole.
Good morning. It's me, Nicola Hurry. The other people don't live here currently.
Okay.
So,
All right. What is plaintiff's claim?
Right now, I am showing $1,818.59, cost of $270, grand total of $2,088.59.
Give me that total again. I'm sorry, counsel.
No problem. I have $1,818.59 of rent, cost of $270, total of $2,088.59, Your Honor.
All right. Thank you.
You're welcome.
And Ms. Lahire, how are you guys going to get that paid?
I haven't spoke to Patrice, but I have half of that. And I'm just coming back from a temporary layoff. So I'm going to make another payment next Tuesday or Wednesday morning.
Okay, let's do this. How much do you have now that you can pay?
Let me look at my money orders. I got 935.
$935?
Yeah.
Okay, so that you could pay, if you had to pay that today, you can pay that today, correct?
I can drop that off to Patrice.
Okay, and then you said another payment next week, Tuesday or Wednesday. How much could you pay then, do you think?
Probably another 800, and then
Okay.
and then
Go
the
ahead.
only other issue is like I said, I get paid like that following Tuesday, and I think that would be the 10 days, and and with the water bill and everything, I wouldn't be able to get it to them until Wednesday morning.
Okay, Mr. Lahire, take a breath. Let's do this, all right? I know you're trying to work it all out, but get the 935 to them today, okay? Get that over to them, and then you're going to pay the 800 next week.
Yep.
Okay, and then what I'm going to do is I'm going to adjourn it out to next Friday, November 21st, 2025 at 2 p.m.
Okay.
Okay? And you'll have to appear at the courthouse if you don't have everything paid. But what you can do is talk to the landlord and see if you guys can work that all out and get this done.
Okay. And then Patrice, I'll drop that off before 5 o'clock to you.
Okay, thanks.
All right. Thank you, folks.
Thank you.
Pines of Clover Lane versus Brittany Berkeley.
Brent, take it for plaintiff.
Brittany Berkeley, they are not checked in. You have been sworn. You may proceed.
Thank you, Judge. At this time, we would move for a default possession only judgment. I'm showing rent to retain at $2,656.02. There is cost of $175, leaving a redemptive total of $2,831.02. We ask for a written 10 days.
All right. Judgment to the plaintiff by default for possession, redemption amount in the amount requested with the writ issue in 10 days. Pines of Clover Lane versus Roberto Banda III.
Brent, take it for plaintiff.
Banda, not checked in. You may proceed.
We're asking for a default possession only judgment, Your Honor. Rent to retain is $1,382.16. Cost is $175, leaving a redemptive total of $1,557.16. Written 10 days.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ issue in 10 days. Pines of Clover Lane versus Evan DeCusson.
Brent, take it for plaintiff.
Dawson, not checked in. You may proceed.
It asks for a default possession only judgment. Rent to retain.
Hello.
Hi.
What's your name?
Evan DeCossin, sir.
Okay, very good.
Sorry, they never checked me in, but
Okay, well, do you have a camera? You'll need to turn a camera on, please, sir.
Oh, yeah, sorry, here. Let me sort it.
All right, thank you.
There we are.
All right, what is plaintiff's claim in this case?
Right now, I have rent at $2,856.54, cost of $175 for a grand total of $3,031.54.
Sir, how are you intending on getting that paid?
I waiting on a check. It's gonna be a couple weeks, and I've been in a car accident recently, so that has put me on a short-term disability, which has severely cut my wages. Also
Okay.
Yeah, go ahead.
Go ahead.
I was gonna say also my lease is up very soon, and I'm planning on vacating as soon as possible. Also, I don't know if that makes any difference here.
Well, it may make a difference in terms of getting this paid, but what I'll do, I'll adjourn this out to November 21st, 2025, 2 p.m. At 2 p.m. That's an in-person hearing. What I would suggest that you do, sir, if you're going to be receiving a check soon, is to contact the attorney's office that's on your paperwork. See if you can work something out before our next hearing.
Okay, and can you repeat that date again, sir?
Yes, the 21st. November 21st. 2
At what
p.m.
time? 2 p.m.
2 o'clock.
Thank you, sir.
All right, thank you.
Yeah.
I think that's it for you, Mr. Ingram. I think that's all I
That's it
have.
for now. Thank you, Judge. We'll see you
All
this
right.
afternoon.
Take care. Yeah. Bishop Pickering LLC versus Mohammed Sise.
Good morning, Your Honor. David Fancher on behalf of the plaintiff.
And Mr. Sise is here. All right. What is plaintiff's claim?
The rent that's owed at this time is $1,105. Court costs of $175 for a total of $1,280.
Sir, how are you intending on getting that paid?
I did a payment on the 7th of November of $1,150.
Do you have that?
Yes, I
Mr.
already did the
Fancher?
payment online on the portal.
Your Honor, we received that. That was for October.
Got it. Okay.
Okay.
So when do you think you can get this $1,280 paid?
Right now I can do a partial payment of I can pay half of that by the end of next week, and then I can do the other half a week or two later.
Okay, so you can pay what, about 700 or 650
By end of next week, yes.
Okay. So
That's
can you get
Friday.
that paid by the 13th? I mean, what am I doing? By the 20th?
Yes, sir.
All right. So I'm going to put in here that you're going to pay 650 by the 20th. I'm going to adjourn this out to November 21st, 2025 at 2 p.m. I'd suggest that you call the attorney's office, see if you guys can work something out for that balance prior to that date. Okay?
All right. So do I have to appear on the 21st at 2 p.m. in
You
person?
do have to appear on the 21st. That's in person if everything is not paid.
Okay. But if I pay everything before that, then I don't need to appear, right?
If everything is all paid up, then I don't need to see you.
Okay, sir. Thank you.
I don't mean to put it that way, but you don't need to come down to the courthouse is what I mean. All right?
Okay.
Okay.
Thank you.
Thank you, sir.
Thank you.
Court does call the case. Bushwood Properties versus Austin Zamora.
Good morning, Your Honor. David Fancher on behalf of the plaintiff.
Good morning, Your Honor.
Okay. Good morning, sir. All right. What is plaintiff's claim?
In this case, there's rent owing in the amount of $1,970. Court costs of $175 for a total of $2,145.
Mr. Zamora, how are you intending on getting that paid?
I have an appointment scheduled with the VA this Monday at 2 o'clock, the 17th, 2 o'clock. I'm planning on using the VA to cover those costs.
Okay. You're a veteran, sir?
Yes, sir.
Which branch?
Army.
Man, there's Army, Air Force. All right, fine. I'll let it go.
We'll get there, Your Honor.
All right. So you have that appointment next week, Monday?
Yes, sir.
All right, I'll let that certainly happen. What I will do is I will adjourn this out to November 21st, 2025, 2 p.m. That's an in-person hearing, but hopefully we'll have some news or something in terms of that process. Okay, sir?
Your Honor,
Got it.
may I, should he fill out the 539 form and get it into the court so that if
He can, except that he's not going to have a tracking number.
and actually that's fine because he actually went into my client's office and filled out the paperwork. So assuming that it's not done next week, we'll probably wind up adjourning it a couple of weeks out anyway.
Right, in any event. All right. Okay, sir?
Yes, sir.
Thank you. Bushwood Properties versus Crystal Beth.
David Fink here on behalf of the plaintiff. I think there's a second defendant there also, Your Honor.
Yes, Justin Nicholson.
Yes, he is incarcerated at the moment.
Yes, he is. We were aware of that. Okay. All right. What's the plaintiff's claim?
The rent that's owed is $2,603. Court cost of $188 for a total of $2,791.
All right. Ms. Dove, how are you intending on getting that paid?
Well, actually, I had spoke with the manager of MTH, and she told me that I could go ahead and send a check through Chime. She said that would be fine, and I sent it October 31st for $1,300. And it's not showing that it has even gotten there yet. It said the 16th it should get there, which I don't understand why it's taking so long, but I do have proof of that I had paid the $1,300, and then the remainder, right now I have $700, and then I get paid again on Friday, so I can have that in.
Okay, so there's $1,300 that should come off of this by the 16th.
Right.
You have an addition, you have $700 now.
Yes.
And then you got another check coming next week.
Yes, sir.
Yeah, okay. All right. It sounds like a plan, though. You've got 13. Get the 700 paid to the landlord early part of next week, say by the 18th. Okay.
Okay. Will do.
And then you'll have the balance that's due. And when do you get paid?
I get paid on Friday, but a lot of the time I get it on Thursday from, to a day or two early, depending on when he gets the checks in. So
I got you. Okay. So if you get that and pay it and get everything paid up, then I don't need to see you next week.
Okay. All right.
But make sure, 2,000 of this is going to come in, then you're going to have about 788 or a little under 800 that you're going to need to pay. All right. So what I will do is I'll adjourn it out to the 21st, 2025 at 2 p.m. That's an in-person hearing, as I've told everybody, but if you're all paid up, you don't need to come down.
Your Honor, can I ask a question?
Yeah.
Yeah.
I'm not sure, I'm not really familiar with how Chime works. Is there a way for Ms. Duff?
Apparently not very well, according to Ms. Duff, but that's okay. No.
I guess my question is there a way of finding out if that check cleared? Is it like a regular check that you write on a bank account?
Yes, it would be it's a personal check.
Check. Yeah.
From my checking account. Yes.
Have you verified whether the check cleared yet or not?
I have not, but I know they took the money out as soon as they sent the check, automatically put it. So
okay, so it's that kind of an account where it doesn't do any good to check.
And somehow or another, she's able to track that there's going to be that it's coming through on the 16th.
Right. That's what Chime says. But I'm going to call them today and see if they have got it at least.
So Chime takes the money out of your account and then sends it and they verified that we should have it by the 16th.
Yes, it says arrival by the 16th.
Okay, I'm glad they're delivering on Sundays, but okay.
Well, see that, that's what my chime says.
All right,
By
well,
the 16th.
Ms. Duff, you've got my phone number. Call me next week.
Yes, I sure will. Thank you.
Thank you, Ms. Duff.
All
Bushwood
right, have a good day.
Properties versus Antonia Benton.
Good morning, Your Honor. David Fanter on behalf of the plaintiff.
Good morning. How you doing?
Oh, there you are. I'm doing great. How about yourself?
I'm feeling a little better. Thank you so much.
All right. Very good. All right, Mr. Fantera, what is owed on this case?
He has a rent balance of $705, court costs of $175 for a total amount owing of $880.
All right. Ms. Brenton, how are you going to get that paid?
I didn't even know I owed this until Tuesday of this week, and so I've been in and out of the hospital lately, and I've been in the hospital all week, and so I went and talked with my case manager yesterday, and he called SOS, and SOS called me and let me know that we was going to fix this Monday.
Okay, SOS contacted you?
Yes, sir. They called me twice. I talked with Grace first to confirm who I was and give her my information. And then Caitlin called me back later on in the day yesterday and told me we would take care of this Monday.
Mr. Benton, can I just clear something up so that maybe in the future we don't have an issue?
Yes, sir.
We've been receiving $950 from Section 8, but your rent's $1,000, so going forward, you have a $50 a month balance, and you hadn't paid anything since March, which is how this balance got large. Do you understand that?
Yes, sir. Here's what happened. When I first had my accident, I called my case manager and explained I was in an accident and my problem, my situation, and she, at the time, she's not in the office anymore. I have a new case manager. His name is Curtis. She's not even there anymore. She's transferred somewhere. But what she had explained to me is that because I never applied for it, and I've never had it before, is that I was eligible for a letter called a hardship letter, and that she was going to apply for me. Well, Curtis noticed yesterday when I talked with him, when I went to the office, he noticed that I actually talked with her about it, but before she transferred, she didn't actually push it through. Well, I didn't know that. I thought she actually pushed it through because I haven't received any paperwork.
And that's how they're going to check. That's how they're going to cover it and then cover you into the future potentially, right?
So it sounds like then Section 8 actually may go backwards and pay the extra $50. Is that what you're saying, Mr. Benton?
Yes, sir. What's amazing about this is my entire voucher covers my entire rent, even if it's late, and Curtis noticed that. So I shouldn't be in this situation in the first place. It's just that
here's what we're gonna do. Let's try to get this part, the major part of this, arranged next week.
Yep.
I can't worry about the future necessarily at this point, but let's get this taken care of. Okay, Mr. Benton?
Yes, sir, definitely.
Yeah, and I'm gonna reach out to the supervisor.
I'll adjourn this out until November 21st, 2025, 2 p.m. Okay, and if it's not all cleared up at that time, Mr. Benton, that's an in-person hearing, but you're down at our access point, so I know you know how to get here.
Yes, sir.
Okay,
yes, sir.
all right. Okay, we'll talk to you then. Thank you.
Just to say this, I will reach out to the Section 8 supervisor and see if there's something we can get done on our end too.
Excuse me.
Yes.
Do I stop at the desk or anything?
Your file's not down there. Your file's down in the courthouse. But if you've got the time and everything, then you don't need to stop at the desk. Just show up next week.
Can you please tell me what time I got to be here?
2 p.m.
2 p.m. On the 21st?
Yes, sir.
21st. Okay. That's if this is not cleared up?
Yeah, that's if everything's not cleared up.
Okay. Thank you.
Thank you, sir.
Your Honor, I just want to clarify. I have a phone number Are the last 4 digits of your number 2243?
Yeah, yes, sir. Yep.
Okay, if I can clear it up on my end, I will call you so that you know that you don't have to show up.
Okay, thank you. We definitely should be taking care of this Monday because she assured me we'll take care of it Monday.
I got
If not today.
Court calls the case of Ian Greenlee versus Michael Bailey.
Good afternoon, Your Honor. Good morning, Your Honor. David Fantier on behalf of the plaintiff.
Mr. Bailey is here. I do see.
Good morning.
Okay. Good morning. All right. What is plaintiff's claim in this case?
The amount of rent that's owed is $2,160. Court costs of $175 for a total of $2,335. And I'll just state for the record that he's already been approved by SOS and they are in the process of sending a check. So I believe that over the next week or so, this balance is, and they're going to pay the full balance. So I think
Yeah, by the 21st.
All right. I'll adjourn it out to November 21st, 2025, 2 p.m. Hopefully that all be resolved. Thank you,
Okay.
Mr. Bailey.
So
And if it's not resolved, you'll need to appear. I'll just say that, but it sounds like everything's worked out.
Yep, thank you.
Thank you.
Yep.
Sandy McFiddish versus Leslie Brown.
Good morning, Your Honor. David Fantier on behalf of the plaintiff.
Mr. Brown? He looks like he's trying to unmute. There he is. Oh. Okay, there you go. We got you, Mr. Brown. All right, what is plaintiff's claim in this case?
The amount of rent that's owed is $1,539. Court costs of $175 for a total of $1,714.
All right. And Mr. Brown, how are you intending on getting that paid?
Yeah, the paper that I have, I mean, I get paid every 2 weeks. I can, on the 26th, I get paid. I'll be able to put, $800 down. But what I'm showing on my paper is that I owe $504 for October. I just made a payment yesterday of $400. So I don't, the 1,000 that they're saying that this is for November. So I'm not sure because the paper that I'm showing is 504 plus cost.
Right, but we're now in November, so you owe November. And Mr. Frontera, do you show the 400 he says he paid?
I do not.
Okay, so this other balance, your next pay, you say it's the 26th, sir?
I get paid on the 26th, yes, sir.
All right, so what I'm gonna do is I'm gonna adjourn this out to November 21st, 2025, 2 p.m. That's an in-person hearing, so you'll need to be here. I'm gonna suggest that you contact Mr. Frontera's office, see if you guys can work something out prior to that point in time, okay?
Okay, can you throw me the date one more time? I'm sorry.
It's the 21st, 1 week from today at 2 p.m.
Okay, all right, thank you.
Thank you. Court calls the case of Sandy McFiddish versus Lindsay Love.
Good morning, Your Honor. David Fantier on behalf of the plaintiff.
Good morning, Your Honor.
Love. Good morning. How are you?
I'm doing well, Your Honor. How are you doing?
You know, it's a Friday. I'm good.
Right.
All right. Mr. Frontera, how much is owing on this account?
The balance of rent that's owed is $3,200. Court costs of $175 for a total of $3,375.
All right. Ms. Love, how are you intending on getting that paid?
So I know, so the paperwork that I was reading, I know that's not including this month. So the paperwork that I was reading was $2,200, and I just have to earn it. I haven't contacted anyone. Every time I have in the past, I always get denied. So currently I just plan on earning the money, and I know for a fact I'll be able to pay $1,000 on the 21st, and
okay,
and $1,400 on the 28th. That's where I'm at with it, because that was the total balance in my mind as far as what was previously owed as far as this balance.
Gotcha. Okay,
Yeah.
so here's what I'm gonna here's what I'm gonna suggest you do, Ms. Love.
Yes, sir.
I'm gonna adjourn this out 1 week to the 21st, 2025 at 2 p.m. Okay?
Okay.
And then I'm gonna suggest that you contact Mr. Fantera's office and see if you guys can work out a payment plan to get yourself caught up.
Wonderful. Yes, I
Okay.
will contact Mr. Fantera.
All right, fantastic. Okay, thank you.
All right. Thank you. Have a good day.
You do the same.
Thank you, sir.
YPF 16 LLC versus, is it Inicia Boykin? And is it Casti? It's cut off. Sheet. Is it Castellan Cotton Roberson?
Good morning, Your Honor. David Fantera on behalf of the plaintiff.
Boykin, Cotton Roberson, Robertson, neither are checked in. I don't know. Did we swear him in though? If you raise your right hand, you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God.
I do.
Go ahead, sir.
Your Honor, I'm David Fantera. I'm the attorney for plaintiff in this matter, and as such, I'm familiar with the books and records as they relate to these tenancies. In this case, there's rent owing in the amount of $2,085, court costs of $188 for a total of $2,273. We'd ask for a judgment for possession with a writ after 10 days if that amount remains unpaid.
Judgment to the plaintiff, that is by default. For possession, redemption amount is in the amount requested with the writ issue in 10 days. 103 South Huron LLC versus Joshua Bertram.
Good morning, Your Honor. David Fantera on behalf of the plaintiff.
Mr. Bertram?
1 second.
Oh, there you are. Got him. Okay.
Morning, Your Honor.
Good morning, sir. And what is plaintiff's claim?
There's rent owing in the amount of $835, court costs of $175 for a total of $1,010.
All right. Mr. Bertram, how are you going to get that paid, sir?
I'm going to be paying about $500 within the next day or so. And then my next paycheck will be on the 26th of November, which I should be able to finish paying that off. I did sign up for the Flex app, which will set up auto pay and split my payment of rent into 2 sections. So this won't happen again.
Okay. All right. Okay. I get you. All right. So you're going to pay $500 the early part of next week. I'm going to put by the 18th, 19th. Get that paid. Contact Mr. Fantera's office. See if you can work something out. And I'll adjourn it out 1 week. All right.
Sounds good. That would be the 21st at 2?
Yes, sir. Thank you for listening.
Of course.
Thank you so much for listening. It's an in-person hearing, so you'll need to be down here unless you got it all paid. Okay, sir?
Yes, sir.
All right. Thank you. Have a good one. 22 Barker Road LLC versus Smoke Shop and Vapes LLC.
Good morning, Your Honor. David Fantera on behalf of the plaintiff.
Good morning, Your Honor.
Good morning. Your name?
Jalal Abdullah.
Okay. So first of all, Mr. Abdullah, you are going to need to have an attorney to represent you in this matter because this is a corporation.
Yes, that's why I couldn't find an attorney yet, so I might need like some additional time.
Okay.
To,
so what I'll do?
Find an attorney that can represent me.
Pardon?
I just need some extra time to get the attorney.
Okay. So what I'll do is I'll give you a week to accomplish that task. I'll adjourn it out to the 21st, 2025 at 2 p.m. That's an in-person hearing. So contact an attorney and then they'll need to be here at that time. Okay?
All right. Thank you, Your Honor.
All right. Thank you.
Your Honor, I want to point out one thing. It's my understanding that they are moving out, and this was a possession-only case. So if they move out and turn in their keys before next Friday, the case would be dismissed.
Yes, we are willing to move sooner than Friday. We are working on it right now. We're trying to repair the stuff inside the shop so we could return everything back the way it was.
All right. If we have the keys, Your Honor, then I would be dismissing.
Got it. Okay. All right. Thank you, Mr. Abdul.
Thank you, Your Honor.
Bishop Pickering versus Peterson, Sandy McFiddish versus Candace Reeve, and Red Lion Apartments versus William Irving. Those matters are dismissed on plaintiff's motion without prejudice.
Thank you, Your Honor. Have a good weekend.
That's it. I miss there for the next block. Yeah. Oh, okay. Because I see people dancing around on my screen and I just want to make sure we're not ignoring. All right. We'll come back, call our 10 o'clock block momentarily. Court's going to stand in recess. Thank you.
That have came in recently for either case.
When would you like to receive a phone call from her, Ms. Kraus?
I'm uncertain as to when she's obtaining the phone. I mean, I would have liked one yesterday, but I don't know when she will have that.
I will be getting it after 3:30 today. So if I do not get it before you shut down today, as it is Friday, I will call you Monday morning.
First thing Monday morning at 8 a.m.
Yeah, because I work at 9, so you will have to get it first thing.
All right, here's what we're going to do. Ms. Mastaw is going to make a phone call to a friend of the court and speak with Ms. Kraus Monday morning at 8 a.m., at which point she will give the friend of the court her current address. She will give all necessary information as to her employers, including federal ID numbers, paycheck stubs, etc. She will give the proper telephone number, and she will indicate when she is to make, when she will make her $86 payment for November. We're going to adjourn this matter for 30 days to December, at which point Ms. Mastaw will also have made a payment for December prior to the next court hearing. So Ms. Mastaw, do you understand what you're required to do?
Yes.
All right. Hopefully by the December court hearing, there's income withholding orders in place. If not, we'll adjust things accordingly. Once the income withholding orders are in place, things should go smoothly. But until then, Ms. Mastaw, you are required to meet your monthly requirements. And if you fail to do so, I will treat it as contempt and hold you in contempt, and I could consider jail time at that point. Do you understand what I've said to you?
Yes, sir.
All right, that's all for today then. Thank you.
Thank you. You have a good day.
Two. Next matter is Feliciana Garcia versus Jesse Gonzalez, file 17-16703-UM. Mr. Gonzalez, if you turn your video on, please.
Can you see me now?
I can, Mr. Gonzalez. How are you today?
Good.
All right, Ms. Kraus, can you update me as to Mr. Gonzalez on this matter?
Yes, this hearing was adjourned from October 24th. This specific case is arrears only. The balance is $2,327.44. This hearing was to monitor the defendants compliant with the requirements. The first was to make a specific monthly payment of $50. Our office received a payment of $30 in October, and as of yesterday at shortly after noon, there has been no additional payment. Second, the defendant would obtain employment and report it to the front of the court within 30 days, or the court would find the defendant in contempt and commit them to 7 days in the Otsego County Jail There's been no employment reported as of yesterday.
Mr. Gonzalez,
Yes, sir.
what's going on? Why haven't you made your payments?
Excited. First of all, I
I'm
want to
sorry,
tell you
Keith.
thank you. First of all, I want to tell you thank you for pushing me to be a better guy. I finally got a little job, so I'm kind of excited about that. Today's my first day, and these will be running smooth now. I'm excited. I didn't think I can do it, and you pushed me to be a better guy, so I appreciate you.
Where are you working at?
Right here at the military base. We're doing a roof here.
What's the name of your company?
I don't even know the name. My first day. I'm gonna get all the information after I meet the boss, meet the owner. I'm up here right now with all the guys working. So they're gonna give me a week trial, and they like me already, but I'm a good worker, so they keep me, and then you'll know. But I know they're gonna keep me because I love to work.
Well, I'm glad to hear that. That's a step in the right direction. You still owe $20. You still owe $20 for today's or for this month's payment, and you need to contact the friend of the court to tell them what job you have. When are you going to do that?
Yes, sir.
When are you going to do that?
I'll do that sometime today. Actually, we won't get up till 5. The court's closed at 5. I'll have to figure it out, and I make sure they're going to keep me. So I'll let them know more as soon as I find out more. As soon as I actually meet the main guy that hired me. I went through a foreman, and he called his boss, and they hired me on. I started this morning at 7 o'clock in the morning.
All right. So do you have a cell phone, Mr. Gonzalez?
Yeah. Yes, Your Honor.
All right. Today is Friday. I'm going to expect a phone call to the friend of the court by Friday, the 21st, November 21st. That's next week, Friday. And if you're working full time, you should get a lunch hour. So I want you to call by 1 o'clock, no later than 1 o'clock on Friday, the 21st. And I also expect a $20. That's next week. I expect a $20 payment by then. If you don't, we're going to hold you in contempt of court, and I'm going to issue an order sending you to jail. Do you understand?
Yes, sir. I got you.
All right. Sure. I'm glad that you've got a possibility of a good job there.
Yeah, I'm excited. I'm excited.
All right. Well, get your payment in, get your information in, and we'll adjourn things until the 21st.
Maybe soon I won't have to see you no more. Just making my payments.
Don't take this the wrong way, but I'm looking forward to that day.
Your Honor.
Yeah, me too. I thought
right.
At first I was getting upset with you, but man, thank you for pushing me and made me be better.
I do want to indicate for the court record that we just need to make sure that this job is a job that potentially is a W-2. So we would need that federal tax ID number, because if he's being paid as a 1099, it would fall on his responsibility to make those payments.
You understand?
I understood that.
Said, Mr.
Yes, sir. I think I'm not too sure. I'm going to find out more. I think it is a 1099, but I'm going to find out for sure. And I will let the lady that just spoke I forgot her name. I'll let her know what's going on.
All right, good. Hang on for just a second, because we've got another case with you, and I want to just put all of that on the record as well. So hang on just a second.
Thank you, Your Honor.
All right. The next matter is Melissa Reichstroff versus Jesse Gonzalez, file 18-17322-DS. Ms. Kraus, can you update me as to that file?
Yep. With this file, it was the same requirements. Specifically, though, with this, his monthly obligation is $321. The defendant paid $200 on October 13th. There's been no payment for this month, and then the remainder of last month. And then the current balance on the account is $8,585.98.
All right. Mr. Gonzalez, on this case, I'm going to do the same thing. I'm going to give you till next Friday at 1 o'clock to contact a friend of the court with all of your new employment information.
Understood.
You need to catch up on your payment. So I think there's about $100 and some left that you need to pay. I don't know exactly. I didn't do the math.
Yeah. Yep. I get paid next Friday too, so I'll better drop some money. I have a little bit of money now. I just haven't had it right over there, but I'll try to make it. I'll talk to the lady, see if there's any way I can arrange it, or I can just pay it the electronical way. That way it'd be easier for me to do it like that now that I'm going to have a job.
That's a great idea. So you know what you need to do on both of these cases, right?
Call on the 21st.
Yep. And make the payments on both, and make the payments on both of them.
Yes,
And
sir.
then we'll reschedule this for a month from now to monitor that you're doing what you're supposed to be doing and you still have your employment. And if that's true, we may be able to cut you loose at that point. All right.
I appreciate you, and thank you for pushing me. At first, I was very upset with you, but you know what? You pushed me to do something better. I appreciate it. Thank you.
I'm glad to hear that. Good luck to you, sir.
All right. You have a good day. Bye-bye.
You too. Miracles will never cease. All right, the next matter is Danny Marcinkowski and Stanley Huffman, file 17-16885-DP. We have Mr. Huffman with us.
I do not see him. I do have a Samsung in here that's unnamed. I can ask them to.
Yeah, let's find out who they are. Is there a Stanley Huffman in court today? Would the Samsung device please identify? Ma'am, that's you that's sitting on the pink couch. Would you tell me your name, please? You're on mute. I can't hear you.
Your Honor, that's Miss Lonsberry Burns.
All right, thank you. Thank you. All right, it appears that Mr. Huffman is not present. Ms. Kraus, what do you recommend?
Based on the arraignment hearing from October 27th, part of the conditions, because he paid a payment of $250, then it would be reduced to a PR. Part of those conditions were to appear today. And he has not, so front of the court would request a bench warrant in the amount of $2,250 and $100 in court costs.
So ordered. All right, the next matter is Spencer Hoyt and Jennifer Hoyt, file 19-17760-DM, set for a show cause.
I don't have neither one of them either, Your Honor.
All right, Ms. Kraus, have you had any contact from Mr. Hoyt?
I have had contact, but it was in regards to him submitting information to the friend of the court to address the income amount. Outside of that, I have not. He was ordered to make, because there's a specific court order for $1,012. The balance on the account right now is $19,064.15.
Well, for his failure to appear, then let's issue a bench warrant. What do you recommend for bond?
I apologize. I was quite surprised he wasn't here, so let me just math this. Based on the balance, it would be recommended for $4,800 plus $100 in court costs.
So ordered. Darian Weeks and Robert Kronk, file 19-18022-DP.
I'm here, Your Honor.
All right, I do see you, Mr. Kronk. Looks like we were here on a show cause. Ms. Kraus, could you update me as to that, please?
Yes, this hearing was adjourned from October 24th. The defendant was to make a $75 payment to the friend of the court by 4:30 on October 24th. He did. And it was also indicated the defendant is expected to make specific payments each month to meet his support obligation. If not, the court would find the defendant in contempt at the next hearing if he fails to comply. We did recently, on November 13th, the defendant did pay $86 by specific payment. That was a combination of cash and credit card that's still pending disbursement. Because of the specific payment, it should be applied to this case. His obligation, though, is $200, which does include overdue support. Current support is $144. $56 is towards the overdue. The balance on his account is $9,168.49. The defendant hasn't complied with any support enforcement orders except for a payment back in May of 2025 of $80. At that point, it was paid to be released from jail. We're just seeking enforcement of the order as he's failed to comply.
What do you have to say for yourself, Mr. Kronk?
Your Honor, for those couple months, I was incarcerated, and I've had issues back and forth. Like I said, with I got arrested and I was put back in jail for a little bit because the court's messed up on a no contact. But things are starting to pick up. I started working for a friend, and I'm starting to get money. It's just hard for me to get to Gaylord to make payments to you guys because I have no driver's license or anything like that, and I really don't have anybody because I'm not gonna lie, I've been sober for 2 years now, and it's pretty crazy when you're sober. All your friends tend to die off, and it's pretty rough lately. You know, I mean, I can make another payment. I just got to try to get over to Gaylord because it all depends on how much I get paid, when I get paid, and the jobs are starting to pick up. I could probably pay the rest off, maybe. I mean, I could call somebody today and see if I can get a ride back over to Gaylord, but I might be limited. It's just, I have a friend that goes over there every now and then to see family, and they give me a ride. I got probably $40 more I could probably pay on to my child support. Right now, it's just, with the job that I'm starting to work, it's just starting to take off. I mean, thankfully, I got something for employment because I got holes in my home right now, and they're talking about over $4,000 worth of repairs, and I have no idea how I'm going to figure that out with 4 kids in my house and holes in my ceiling from a tree. But thankfully, it's starting to take off.
Mr. Kronk, you were released from jail in beginning of October, right?
October 7th, Your Honor. And then I spoke to you on the court that day, and then I paid that $70. You told me I had to pay the $70 before my next court date, or I was going to go to jail. And I came in to pay the $86 yesterday. And if I was going to ask the court if you can give me till maybe Tuesday or Wednesday of next week, I could make the rest of the payment. I just got to find a way to get over to Gaylord to pay it to you guys directly at the courthouse. My only issue is I can't pay it over the phone with you guys, but I could pay the rest of the balance for this month. That's not an issue. I just got to figure out how to get over to you guys. I'm currently, they took my driver's license, Your Honor, so I can't drive, and it's really frustrating because I got Charlevoix County. I got to pay child support over there, costs over there, and literally, like right now, I don't have any money to my name to even buy myself any clothes, work clothes, or anything like that for this new job or anything like that. It's pretty much, it goes everywhere to the courts over there and to you guys. And I mean, it's not an issue of paying the money. It's just the issue of getting over there. So I'd ask the court, please, respectfully, if you could give me the next week, I can pay the rest of this month's obligation because I can't afford to go to jail with my employment just starting to take off.
Ms. Kraus,
I mean,
there
it's-
is a, I'm sorry, Mr. Kronk, let me talk for a minute. Ms. Kraus, there is a independent payment place called MISDU in Lansing, right?
Yes,
So he doesn't need to come to Otsego County?
he doesn't need to, because he does have more than one support case. Payments that are made will be dispersed based on those guidelines.
Crap. Sorry, looking for a pen.
I just know that he's indicated since May that he's had a job or a potential job. And it seems every time we're back here, he's requested an additional exception to the case, and then it's just resat.
Well, I'm actually able to make my payment, so that's I can get verification from him if you guys would like. I can get something from him in writing saying that I work for him, if that's what you want, or if you want me to have him call you guys directly and speak with you guys about it, I can have him call you and notify you guys.
Mr. Kronk, what I want is for you to pay your bills on time every time. That's all I want. I don't want to talk to anybody else. I don't want to have verification from anybody else. I simply want you to make your obligations when you're supposed to make them. And so far you haven't.
All right. What was that? What was that website or the place you said that I can make it directly?
Ms. Kraus,
if you don't mind
that
me
information?
asking again?
Yes, it's MISDU. He has received information in regards to how to make payments with pre-show cause letters that he has received. I do see that between the two cases, and again, it's neither here nor there, but his obligation for both cases just to comply with what's ordered is $398. But again, any payment being made would disperse.
That's the hard part because they. Sorry, I didn't mean to interrupt you. I was
looking
when you guys just now informed me of this one, because I've always had to come over to you guys to pay. I didn't know that there was a direct line, so I could probably make a payment.
You can
today
make
if you guys
payments
give me
by
the rest of the
credit card as
information.
well, but in regards to that, again, they are set to the disbursement unit and there are dispersed based on the guidelines. Looking at the history of the case, the only payments that have came in recently for either case are the specific payments that have been requested per this order.
Because I've been incarcerated since June of last year, or this year. Because last year I had the issues, and this year it was the stuff with the driving unsuspended. So I was incarcerated for a while, and then everything up till October. I mean, but everything's just now starting to take off, thankfully. And I mean, like I said, now that I got this information, I can make a payment to you guys over phone and stuff like that. But I mean, it's just starting to take off. I can't afford to lose my payment.
Mr. Kronk, I've heard you say that 4 times now, and I understand it, and I've heard you. Okay, so here's what we're going to do. I'm going to give you. We're going to reset this matter for a month from now, so the middle of December.
Okay.
You're going to have to make your payments in full on both cases. So, Ms. Kraus, that's that $398 total. Is that correct?
Yes, it appears the monthly charging is $292 and there is the overdue support of $106. So it appears, yes, $398 would be what would need to be the case. Yes.
And that would be this case and his other case? Just this case?
That would be both cases combined. What I did was do a search with his individual ID. So the total monthly charging, the obligation is $292. And then the ordered on arrears, which the system may have factored in something specifically for the other case. But again, even if anything is paid over, it would just disperse towards arrears cases.
I put in a reevaluation for you guys and for Charlotte County too, because I have 6 kids total. I have 4 that currently live with me, and it's rough. I got 4 children that live with me that are under the age of 5, and issues with this house. And everybody says call FEMA and this and that and that. There's places that'll help you. That's the biggest load of crap I've ever heard in my life, because literally this tree came through my house and there's nobody. DHS, everybody, and it's just. Pardon my language, it's a shit show. And, it's crazy. I know things have been rough, and I get incarcerated for possession of drugs and I didn't have nothing in my system, anything on me or anything around me. I'm standing, not even by anything. And now I'm fighting for my freedom.
Mr. Kronk, I can't do anything about your criminal cases. All right. So here's what I'm going to do. I'm going to give you a month to pay your $398 per month. If you don't do that, I'm going to put you back in jail.
Wait a minute. It's not $398 at all.
It is on all your cases.
200. It's 200 to you guys. My obligations with Charlotte County has nothing to do with Otsego at all. So that's not a factor in our case at all. You cannot factor my payment of Charlotte County in with your county because that's a whole total separate case. My obligation and my cooperation with them has nothing to do with my case in Otsego. So that's not at all a possible or anything that goes by Michigan court rule that you can honestly add my Charlotte County case with my Otsego. That's irrelevant to our case. Whole totally different trial. So my support with you guys is $200 a month. So that's what my obligation to you guys is, not $394 a month. I'm not paying Charlotte County to you guys. I pay Charlotte County directly to themselves.
Mr. Kronk, I've heard you. Every time I try to start talking, you keep talking more.
I apologize.
So just take a breath and let me have a moment. Ms. Kraus, how much does he owe in arrears?
On the case for our county,
Yes.
the arrears balance is $9,024.49.
How much is he paying in arrears towards the arrears monthly?
Just recently with the ordered on arrears is $56.
So what's his total monthly amount for us, including his ordered on arrears amount?
$200, $144 for current support and $56 towards arrears.
All right, Mr. Kronk, you owe me $200 before the date of the next court hearing, which will be sent to you in the mail. That'll be in December. If you don't pay that $200 between now and the next court date, I'm sending you to jail for 7 days. Do you understand what I've just said?
Yes, sir, I do.
Make it happen. I don't want to hear any other excuses about your house or your criminal case or anything else. Make your payment. That's all for today.
All right, thank you, Your Honor.
Next case is Ashley Bagby and David Losiewski. It's file 14-15600-DP. All right, I do see Ms. Bagby is with us. Ms. Spillane, is this your matter?
I believe
no,
Mr.
Judge, I'm
Brzezinski
covering
is
this
doing
one.
This one.
All right, thank you, Mr. Brzezinski. Could you update me as to this one, Mr. Brzezinski?
Yes, Judge. This hearing was adjourned from October 10th. The court ordered the following. The plaintiff was to provide current income and employment information to the front of the court office. The office has not received that information. Plaintiff was to begin making payments to meet their current support obligation of $392. No payments have been received. And then the front of the court was to prepare an ordered on arrears recommendation. This was completed. Plaintiff objected. The objection hearing is set before referee legal on November 19th. And then plaintiff was to appear today for a hearing. And the order indicated that she might be found in contempt if she did not comply with the order.
Ms. Bagby, can you tell me why you didn't supply the income and employment information to the friend of the court or make any payments?
Yes, I can, Your Honor. I haven't been able to pay anything yet as I was just working part-time and I still am. And that is in trade for a vehicle, actually. I did request a review for child support, which was mailed last week, and also the objection. But I am now going to be getting a Tahoe. It's in the shop right now, getting a new thermostat, bearings, and tires put on it. But it's going to be out next week, and by next weekend, I will be able to hand in applications for an actual W-2 job. So I have not been able to. I don't have any money yet, but I am trying, and I am working part-time in trade for a vehicle. I'm not getting cash, so I cannot provide payment. I will be able to apply for jobs next weekend, though.
Why aren't you able to apply for jobs now?
I don't have a vehicle, Your Honor. I lost my vehicle 2 years ago when I was in jail for 6 months on charges that were just finally dropped. I have been struggling for a couple years because of charges and sitting in jail for 6 months on charges that were dropped on appeal. And I have been struggling to rebuild my life ever since. I have a vehicle that's coming next week finally, but I haven't had a vehicle.
When did you get out of jail?
I got out of jail in April, I believe, and then I was court ordered for 90 days of treatment, psychiatric treatment. And then we had our last hearing in which I said I am able-bodied and ready to go to work and seeking employment. I do have a part-time job, which is going to provide me with a vehicle to go and get an actual full-time W-2 job.
Where do you live now?
I live in Sheboygan County, Your Honor.
Is there no bus system in Sheboygan County?
Not in the middle of the woods. I'm about 15 minutes out of town.
How do you get groceries?
My boyfriend. He's also the one who's paying for the vehicle. He's also the one that gives me a ride to go clean part-time twice a week. He's also the one who pays our rent.
What would stop him from giving you a ride to work every day?
Because he works every day. We need two vehicles.
You could get up 15 minutes early, drop you off, and he could go to work and then reverse that on the way home.
Well, Your Honor, he's been using his mom's vehicle. We don't have a vehicle. We're getting a vehicle.
But he's using the vehicle every day to get to work, right?
Yes.
So what stops you from riding with him?
Because he leaves at 6 in the morning and he works till 3 in the afternoon. And I haven't been able to find a job in Sheboygan County in downtown where he drives to at 6 in the morning to go to work.
What kind of
We're
work
going to
does
be
he
able
do?
to. He does construction. He does indoor, outdoor, small construction with, oh, I'm so sorry. I can't think of his name right now. Ray Wheeler. Wheeler and Sons Construction, I believe, is the name of the business.
You're telling me that you can't find a part-time job or couldn't find a part-time job at a gas station or a fast food joint in the morning?
No, Your Honor, I haven't been able to, and I'm actually cleaning for Ray. I'm working, it's his dad's house that I'm cleaning, and it's going to be construction cleans for his company that I'm also doing. So Ray's actually the one who's gotten me in the door and lined up this vehicle for me so I can go get a job. So, I mean, I have tried, and in trying, I have found people who are actually trying to help me too. But I would also like to remind this court, and I'm not sure if you're familiar with this, Your Honor, I tried presenting this rape case. So I hired Mary Beth Kerr in February of 2020 to present a rape case. My daughter's a product of rape, and Mary Beth Kerr did not do that, blaming COVID. Then in December 2021, I tried presenting this rape case myself, in which Scott Beatty did not allow me to call any witnesses. So I am trying to comply with the court.
What does that have to do with anything?
It has to do with everything, Your Honor, I know that it is illegal for my rapist to have custody, and I am trying to comply with this court, and I am trying to get some money coming in so I can try and make you guys happy, but at the same time, I actually object to paying anything because she's a product of rape, and it is illegal for a rapist to have custody. It's also very illegal the way that Mary Beth Kerr did not present the rape case, and it's also very illegal how Scott Beatty denied me calling any witnesses in December 2021. I went crazy after that, not gonna lie, but I'm doing the best I can to rebuild and trying to comply with this court's orders in order to give my
Clean up your
rapist
room.
money for successfully raping me. It blows my mind, but I have done everything that I can. I do have a job working part-time, cleaning for Ray Wheeler. I will be doing construction cleans for him also, and I will have access to a vehicle so I can go get an actual W-2 job, hopefully by next weekend. All to pay my rapist money for successfully raping me after sitting in jail for 5 weeks.
All right, ma'am, I've now heard you tell me that same thing 5 times in a row. I heard you the first time. I don't need you to tell me it 4 times after that, all right?
Yes, Your Honor.
I'm going to give you the benefit of the doubt. We're going to simply adjourn this matter for 30 days. That will allow you also to have your objection on the current support obligation heard and a determination made of what amount would be appropriate for you to pay. I expect to hear at that next court hearing that you've already notified the friend of the court of your employment, your new employment, and you've already made a payment on your obligation, whatever that is per month. And if those things are not done, I'm going to consider contempt of court. You understand what I've said?
Yes, I do, Your Honor. I do have one question, if I'm allowed.
Go ahead. Go ahead.
As far as the making payment, are you asking about payment for the support that's right now, which is over $300, or is this in the recalculation, which I requested?
You're going to make whatever dollar amount is set after your objection period, after your objection hearing. So whatever dollar amount is set at that hearing, I expect that amount to be paid prior to the next court hearing that you have with me.
Okay.
You're on notice that right now that some amount is going to be due. It's just a question of exactly how much it is. So you should be working towards getting funding for whatever that amount is going to be. So you should be able to make it shortly after the next court hearing that you have on the objection. So I'm giving you a month to make that payment, whatever it turns out to be. And then you're also going to be notifying the friend of the court of what new employment you get. If for some odd reason you don't get employment, then you'll need to notify the friend of the court of what steps you've taken to look for employment. And I typically consider 10 applications per week to be a minimum. You understand all of that?
Yes, I do, Your Honor.
Any additional questions?
No, Your Honor.
All right. Mr. Brzezinski, did you get all of that down so that we can have that in our order?
Yes, Judge. I just want to clarify one thing.
Go ahead.
The objection that Ms. Bagby filed was only to the ordered on arrears recommendation. If she requested a review, she could have. I'm not aware of that. So there will be no change to the current support obligation of $392, even after the next hearing with referee legal. That's only to address the arrearage payment at this time.
All right. Then she's on notice of how much the minimum amount should be. And if it goes up from there, as for an ordered on arrears amount, should be required to make that payment also. All right. That's all for today. Thank you. Yes.
Mr. Brown has asked that we hear the Lounsbury Burns cases. He's got mediation in 5 minutes.
All right. Next matter is Jessica Lounsbury Burns versus Jonathan McMurphy. That's file 12-14631-DS. You see Ms. Lounsbury Burns. Mr. Brown, is this your matter?
It is, Judge.
Ms. Spillane, is this your case as well?
Yes, sir.
Could you update me on this, please?
Absolutely. So the plaintiff was arraigned on October 22nd. The bench warrant was recalled and bond was reduced to a $1,200 PR bond with the following conditions. The plaintiff was to inform friend of the court where they were going to go to detox, which she did do. And then she must inform us when she was released, which she also did. And then you ordered her to do 10 weekly job searches, which she did do, and she was ultimately hired. And then she was also, prior to November 4th, to provide documentation from a doctor or detox facility regarding her diagnosis, work restrictions, and any kind of follow-up requirements for a friend of the court. We have not received anything regarding that. However, with her now being employed, we're just waiting for the income withholding order to become active. And she understands that she does need to make payments until that is active.
Mr. Brown, what do you think we should do?
Your Honor, if I could inquire as to what the payments are, and is this an arrearage payment as well, or are these just straight payments?
My apologies. Her monthly obligation is $256 with a balance of $7,372.34.
And do you know, or maybe this would be something for Ms. Burns, when this withholding order would go into effect?
It can take 6 to 8 weeks depending on the employer.
Your Honor, I would ask to have the matter adjourned out. Well, when is the last payment? When was the last payment?
May of 2022.
Your Honor, I would ask the matter to be adjourned out. It does appear they had a lot for her to do. For the most part, she has done all of those things. She did put out her application. She did obtain employment, and that should give her an opportunity to start making those regular payments by herself for at least a few weeks until that withholding order kicks in.
Ms. Lounsbury Burns, is there anything that you want to say on your own behalf?
I tried to get my doctor to send you guys and stuff. Yes, I've been working, I'm going to keep working. I'm really sick and I haven't had a job in a while, but I'm going to keep going. I may be really sick. I'm breaking out with my MRSA. I'm going to continue until I can get help from my doctor.
Okay.
It's going to be tip wages mostly.
I'm sorry, I didn't hear that last part.
I'm a server, so it's going to be like more tips. So as long as I can get better and not be so sick when I go in, I just want my full paycheck taken.
Well, I'm glad that you have got a job. That's good progress. So I think I am going to do what your attorney suggested, which is adjourn this out. Let's do that for 8 weeks. So 60 days. In that period of time, ma'am, if there's no income withholding order from your job, you'll need to make your payments on a regular basis there. And at the end of the 8 weeks, I'd like the friend of the court to do a petition or a recommendation for ordered on arrears amount that will be added so that we can make some headway towards this arrearage of $7,300. You'll have an opportunity at the end of the 8 weeks to object to that if you think it's inappropriate. But we'll have a hearing in 8 weeks to see how well you've been making your payments, and then we'll consider the ordered on arrears amount at that time. Ms. Spillane, is there anything else that you would ask the court for?
No, sir.
Mr. Brown, anything else?
No, Your Honor, thank you.
Ms. Lounsbury Burns, is there anything else from you?
No, thank you.
All right, that's all for today. Thank you all very much.
Thank you.
Heather Hale and Michael Trombley, file 11-13878-DC for status conference. We have either one of those parties present with us.
I do not see either one of them, Your Honor.
All right. Ms. Spillane, have you had any contact from Ms. Hale?
I have not.
Looks like we had a show cause adjourned to today's date. What are you recommending that we do for her failure to appear?
Well, considering she has been making her payments, I'm hesitant to ask for a bench warrant. I think maybe either dismiss or adjourn out.
How long has she been making her payments now?
We've have 3 solid months where she's made the minimum, this is an arrears only case. She's ordered to pay $50 ordered on arrears, and the balance is currently sitting at $2,203.33, but $50 has not been credited to that balance yet. It was just recently made.
All right. Given her 3 months of payments, let's dismiss the matter, and we can always bring it back if she fails to make payments in the future. Next case is Katrina Thompson and David Thompson, file 17-16811-UM. Do we have the Thompsons with us?
We do not.
Ms. Spillane, have you had any contact from David Thompson?
No, sir. I did attempt to call him, however, was not able to make contact.
There's also a petition for recommendation for ordered on arrears amount. Is that scheduled for today?
It is. He has until the 17th to object to the recommendation. The recommendation came out to $399 ordered on arrears.
All right, we'll just let that sit until his objection period has run out. For his failure to appear today, what do you recommend?
I would recommend a bench warrant. He does not tend to appear for any court hearings, and we have had luck actually getting money on this docket with the bench warrants.
All right, how much do you recommend for that amount?
I would recommend $1,200 plus $100 for court costs.
So ordered. Wooden tubs.
That was a case that was taken off.
Next matter is Riley Regal and Daniel Stafford, file 24-19747-DS, set for a status conference or show cause, excuse me. We have either Ms. Regal or Mr. Stafford with us.
We do not.
Ms. Spillane, have you had any contact from Mr. Stafford?
I have not.
He made his payments?
He has been making his payments. I do think it would be appropriate to dismiss in this matter.
Let's do that then. To order.
Your Honor, we have Mr. Huffman from your 9 o'clock hearing that you issued a bench warrant on. Do you want me to let him enter?
Sure. Of course, I can't find this file.
Yes, there is.
What
I take
happened
full
to-
accountability. That was
What
me.
happened? You didn't appear at 9 o'clock, Mr. Huffman?
My alarm didn't go off. I called the courts immediately as soon as I realized what time it was.
Ms. Spillane, is this Ms. Krause's case?
It is. I can go get her.
If you would, please.
Absolutely.
I called the friend of court too and left a voicemail too.
I'm here, Your Honor. Sorry.
All right, Mr. Huffman has now managed to appear. I believe we issued a bench warrant for him. Was that correct?
Indeed, we did. I just actually had the person that he spoke with when he called pop into my office to indicate he thought his hearing was at 9:30, but it was actually, even if that was the case, it's now 10:15.
Right.
bear with me just a moment while I grab the paperwork.
Yep, go right ahead.
Okay, thank you.
For the benefit of Mr. Huffman, would you update me on this file, please?
Yes, this hearing was adjourned from an arraignment hearing on October 27th. The bond would be reduced to PR bond upon $250 payment. That payment was received. He was to appear today. The defendant would be responsible for making payments until the income withholding is active. The defendant did report to our office on November 10th that he lost his job that he reported at the prior hearing. The second part of the conditions was the defendant was to contact friend of the court upon release. He did get out, but didn't have means to contact the office until November 5th. When he got a phone, he did call. There's been no additional payments besides the $250 that was made to be released from jail.
Mr. Huffman, what's your plan?
Currently, definitely, I've been putting in job apps everywhere I can. It's, I lost my job at Lisa's, I guess, apparently because she found someone that knew more than me or was actually experienced. So that's probably the third time I've lost a job because I learned too slow. But I am currently putting in job apps.
What was your job at Lisa's?
Cook. But she could only give me 2 to 3 days a week, and she was barely giving me that. God bless her soul for still giving me a job in general and allowing me to make the money I did make because it got me out of jail. So I still appreciate that.
So what's your plan going forward?
I do have have someone allowing me to do an oil change on their car today. So hopefully I can get that done today and I can make a payment to you guys today.
How much do you anticipate being able to pay today?
Probably not more than 100 because the oil change, I can't really charge over that much, especially when I'm not a full mechanic. I apologize to the courts too, by the way, for not showing up. I take full accountability for that.
All right, so you can pay $75 today. Is that what you're telling me?
I hope so.
Let's do that. We'll adjourn things out for 30 days. You're going to make 10 applications per week, and you're going to send those to the friend of the court each week. So on Friday of every week, they're going to get 10 applications from you until you get a job. And then once you get a job, you're going to notify them of where that job is. Do you understand that, sir?
Yes, Your Honor.
All right, we'll adjourn this for 30 days to find out how you're doing. I expect a $75 payment today, 10 applications a week, and I'm hoping that you have a job before I see you again. Does that make sense?
Yes, Your Honor.
All right, that's all for today.
Thank you.
Your Honor,
Yes.
could we please revisit the Thompson versus Thompson matter? Regarding the ordered on arrears, we actually had done a petition of sorts to do that without him being able to object to that, given the arrearage guidelines for the
Hang on just a second. Let me find.
Sure.
I apologize for interrupting, but let me find it on the docket here. This is the matter of Katrina and David Thompson, file 17-16811-UM. Go ahead now, Ms. Delane.
My apologies. I made a mistake when I had said that he had an objection period still. This is our recommendation of $399 as the account balance is currently $5,134.05. Given the current guidelines for Michigan Child Support Formula, we could either do the 2% support amount at the time of review, but not less than $50, nor more than half the current support amount. If there is no current support amount, then the monthly repayment amount is the last ordered charge amount, which is where we got that figure. So we were just asking to have that ordered.
Go ahead, do that.
Okay, thank you.
Yep. Next matter is Ashley Link and Tyler Watson, file 24-19769-DP. We have Tyler Watson with us. Ms. Blaine, have you had any contact from Mr. Watson?
No, sir.
Looks like he posted bond in Alpena County prior to our last hearing, and we adjourned it to today's date to address the issue of contempt and forfeiture of the bond. What would you like to do?
I would like to forfeit the bond, and then it looks like maybe he is starting to make payments. They haven't been meeting the obligation, but if it's a new income withholding order, which it looks like it might be, I would like to adjourn just to monitor to see how that's working out.
All right, we'll go ahead and forfeit the bond. We'll adjourn for a month to see how his payments do, and then we'll make a decision about what to do at the next court hearing. Thank you. Darian Yeager and Michael Richardson, file 24-19918-DS.
I'm here, Your Honor.
All right, thank you, Mr. Richardson. Appreciate your patience. Ms. Spillane, could you update me as to this matter?
Yes, sir. This matter was adjourned from October 24th to monitor the defendant's payment and search for additional employment. His monthly obligation is $416 with a current balance of $5,355.14. Last payment received was in October of $200.
All right, Mr. Richardson, how come you're not meeting your monthly obligation?
Right now I've been self-employed and I've been trying to find work. My truck broke down and then my trailer broke down, so I had a week without work. I just paid $200 today because I was able to find a job yesterday that I made $700. So I went down there first thing today and paid $200. That's what I had. I'm trying to pay at least $416 a month right now, but my monthly obligations with rent and other bills are exceeding more than I've been making the last 2 months. And right now I've been searching for other employment along with running my own business, but it's just everything's slow right now, and I've been trying my hardest that I can.
What do you do for your own business?
I do landscaping and handyman services. So like fall cleanup, tree work.
How long have you been doing that?
I've been doing that for the last almost 3 years.
Is that a cyclical business?
I don't understand what that means.
Means it goes up and down depending on the season?
Yes, sir. Like right now with the snow that we had the other day, things just slowed right down. I haven't got no phone calls in a couple of days.
Were you pretty busy this summer?
Yeah, I was.
You put some money away because you knew that a slowdown was coming?
No, I had to buy a different truck, and that recently broke down on me.
Sounds to me like you need a better budget.
I've been working on that.
So what are you doing to search for additional employment?
I've been calling other companies up, other construction companies, other landscape companies, been putting in applications. trying to find an overnight job.
How many of those applications have you put in?
At least 10, 15
In what time period?
in the last month.
I don't know if you heard me talking to another person on Zoom this morning, but typically I tend to tell people they need to do 10 a week, not 10 a month. If you're really hustling, 10 a week is easy. So I appreciate the fact that you're running your own business, but you've got to understand that it is a seasonal business and you're going to have these lulls and you got to plan for them. One way of planning for them is running a budget so that when you're making a lot of money, you're putting some of it away for the downtime. The other way of planning for it, and you can do both, is to have part-time jobs lined up ahead of time. It says if I'm slow in my first business, I can go over here and work at that job, or make plans to work for a month or two at a time at a fast food place or at a restaurant or wherever. You got to plan those things ahead of time. You can't just say, well, I hope it's going to happen. You got to make it happen. Ms. Spillane, what has his payment history been?
Honestly, not great. September, we received $1,500, but part of that was from bond. And then prior to that, it was in July for $500.
Mr. Richardson, in July, you should have been making bank, right?
I was dealing with other court issues. I wasn't able to make as much money as I had liked to back then.
You know that life happens, right? There's always going to be something that pops up and makes life hard to make your payments on, but people are still required to make their payments.
Yeah,
you can't just say, I'm going to pay the court last and then come to me and say, well, I tried. No, that's not how it works. Because you paid $200 today, I'm simply going to move this down the road for 30 days. You bought yourself 30 days. But I better see the full payment of $416 next month when we have this hearing. You understand what I just said?
Yes, sir.
If I don't see it, I'm likely going to consider contempt of court for failure to meet your obligations. You understand that as well?
Yes, sir.
All right. We'll adjourn for 30 days. Make your payment, find yourself some extra work on the side, or get yourself back going again on whatever job you think you want to do, but let's get it done. I'll see you in 30 days. Sabrina Ball and Alan Severns, file 19-17728-DP.
I don't see neither one of them, but I do have a Zoom user in the waiting room and I'm unsure who that is.
Let him in. With the Zoom user that just came into the courtroom, please identify.
Brooke Hewitt.
Do you say that a little louder and a little slower so I can hear it correctly?
Brooke Hewitt, H-U-I-T-T.
Thank you, Ms. Hewitt. You're not the person that I'm looking for, but I appreciate the help there. Ms. Spillane, have you had any contact from Ms. Ball or Mr. Severns?
I did speak with Miss Ball this morning and she was intending on being present. However, she sent me an email during court indicating that she had been called into work and would not be able to attend. She did send me several screenshots indicating what she considers to be proof that the defendant does have an ability to pay something towards his child support.
All right, and you have a motion pending before me today for suspension of the defendant's license.
That's correct.
All right, why don't you tell me what you want me to do as to the license suspension?
I do know that Ms. Ball would like to be present. And I do think that the grounds are there to suspend the license. So if you would like to hear from Ms. Ball, I think if we were to adjourn it out, she would be present, as she cites that she did not receive proper notice for this hearing today.
And you believe that she has information that would be necessary to show ability to pay and willful failure to do so?
I do.
All right, we will simply adjourn this matter out to allow Ms. Ball to appear and testify. Is there anything else that you want to do today?
I don't believe so.
All right, I will leave it up to you to schedule the next court date for that and send notices out to the parties, please. Ashley Ortiz and Morris McCaleb, file 23-19527-DM. We have Mr. McCaleb present with us.
I do not see him.
No one is appearing to the call of the court. I believe this is scheduled for today for, actually it's Ms. Ortiz. Ashley Ortiz present?
Yes. Yes, I am.
I can see a light in the background, Ms. Ortiz. I cannot see you at all.
Okay. Can you see me now?
Apparently you've got two windows at your back. And because of the bright light coming in from those windows, I can't see your face.
Okay. Can you see me now?
Through a cloud. Is there something on the lens of your camera?
Maybe. My laptop broke, so now I'm having to use my phone. I apologize.
Ms. Ortiz, are you still with us?
Looks like she's logging on a different device.
Can you hear me, Ms. Ortiz? Ms. Ortiz, about the only thing I can see of you is a vague outline, and it looks like you're in a room full of smoke.
Hello?
I can hear you, but I can't see you. It looks like you're in a room
I
full
cannot
of smoke.
hear anything.
Ms. Ortiz, can you hear me?
We lost you.
All right, I'm gonna put that case aside for a moment. We'll move on to the next one and we'll try to get it when she gets back and gets her equipment working correctly. Next matter is Faith Nye and Jesse Nye, file 25-20077-DM. I do see Ms. Nye is with us. If you could unmute yourself, ma'am. And I do see Mr. Nye is with us as well. I believe this is the date and time set for a final hearing. I have received a copy of a proposed judgment. Mr. and Mrs. Nye, would you raise your right hand so I can swear you both in, please? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Ms. Nye?
I do.
Mr. Nye?
I do.
All right, go ahead and put your hands down, please. In my review of the proposed judgment, I don't see a proposed property settlement. Have you guys reached an agreement as to who's going to get what and who owns the debts and all that kind of stuff?
Yes, Your Honor.
Yes, we have.
Where is that information located? Ms. Nye, where's that information located?
Sorry, I'm sick at the moment. I wasn't given anything else. That was the paperwork I was given and signed. I'm not sure if there wasn't anything in there.
We did the final review of the paperwork together at the front of the court office on Wednesday, and then I took all the paperwork down to the county clerk and went through it there.
Well, there is a property settlement paragraph on page 6 that says that the plaintiff and defendant are each awarded those items of personal property now in his or her possession, free and clear of any claim of the other, as subject to any indebtedness thereon. Are you telling me that there's no house, there's no debt, there's no anything else that wouldn't be just strictly clothing and jewelry as personal property?
We have both those, but we have discussed and split among each other.
So is there a house with a mortgage on it?
Yes, there is.
Who gets that and who's responsible for it?
I am maintaining the house and the mortgage.
Okay, there's nothing in this judgment of divorce that tells me that. Is there anything other than personal property that still needs to be resolved, that you reached an agreement on? Are there vehicles? Are there boats? Are there mopeds? Are there snowmobiles? Anything like that?
There are vehicles and debt that have been divided accordingly and agreed to. I know we had that documented and turned in, but it was the wrong form. So when we met at front of the court to update the correct form, that was one of the pages given back that was not documented in the final packet that we went through.
I'm not happy with signing a judgment of divorce that doesn't have all of the final terms in it. I think it leads to problems in the future if parties disagree over who is responsible for what. If the person who has been, quote, given the house or given the vehicle doesn't make the payment on it, what is the other party to do if it doesn't say that in the judgment of divorce? You understand what the problem is?
Yes, Your Honor.
All right. So I need something in attached to this in some way that says, here's what the parties have agreed to as a property settlement, and needs to tell me all of the stuff that you guys have agreed on. I'm not mad. I'm just saying that it's a requirement. It's a necessity to do that. Let me see if there's anything else. There was a provision in here for whether or not there was a name change. I didn't see anything in that. Ma'am, do you anticipate keeping the same name that you have now?
Yes, I do, Your Honor.
All right, then that's fine. You both have indicated that there's to be no spousal support. Is that correct?
Yes, Your Honor.
I'm also looking at the uniform child support order. It appears to be backwards. Maybe I'm looking at it wrong, so let me take you to that. In the uniform child support order, there is 3 children mentioned, each being split evenly between the 2 parties. And on paragraph 2C, where it indicates support obligation, there is 3 amounts set: $353 for 1 child, $583 for 2 children, and $707 for 3 children. However, it's my understanding that you guys were going to not have child support and agree that those should be at 0. Is that correct?
Yes, Your Honor.
All right. Because what the uniform child support order says is that those dollar amounts is what is ordered. And then you put in the deviation addendum, the support obligation is at 0. And I think it should be the other way around. I think the deviation addendum should say what the amounts are recommended to be, but not what have been adopted by the court. So I think it should be that the deviation addendum says the dollar amounts and the child support order says 0. And then the deviation addendum goes on in a later paragraph and says why you're not going to use the dollar amounts that were previously recommended. Does that make sense?
Yes.
All right. All right, I think that those are all the issues that I had with the documentation that you submitted to me. So what I think I'm going to do is I'm going to ask that you resubmit this documentation with those corrections being made. And then I will do the final hearing at the time that I have the proper documentation in front of me. So that's going to require you to get a new date from the county clerk's office as to the notice for hearing for that, submit the documentation to them. Again, make sure that it complies with what the friend of the court says it's supposed to comply with. It should be, other than those terms that we just talked about, it should be the exact same of what you got here. And then we'll have that hearing and I'll take the testimony that's necessary at that time. Do you have any questions, Ms. Nye?
I do not.
Mr. Nye, do you have any questions?
I do not.
All right, I'll see you again in the future. Thank you.
Your Honor, we have a call in. It could be Ortiz, but I'm not sure.
Call in on the phone or
Yeah,
call
that's
in?
gonna be a 616.
Your Honor, I think Mr. Fisher is in the waiting room still, so I just talked to him. So if you, I don't know when you're preparing to call our case, but if and when you do, he probably needs to be here.
Yep, go ahead and let him in.
Yep, he's in, and then that phone is in as well.
All right.
Good morning, Your Honor.
Morning, Mr. Fisher. Try to get your case in just a minute. I think I have a one or two in front of that.
Oh, okay, I'm sorry.
No, that's all right. This is the matter of Della Cronin Mead, or also known as Della Rollins, and Brandon Mead. That's file 16-16255-DM. We get counsel place your appearances on the record, please.
Thank you, Your Honor. Attorney Kyle DeBrucker with and on behalf of the plaintiff, Della Rollins, who is seated with me to my left on the screen.
Thank you.
Your Honor, Jordan A. Schoenbrod on behalf of the defendant, Brandon Mead, who last I knew was in the waiting room, and I do not see him.
I do see him on my screen now, so I believe he's here with us. Are you here, Mr. Mead?
Yes, sir.
All right, thank you. So it looks like we have counsel and the parties. Got a bunch of busy stuff going on with this case, so let me get it set up here in my file. Looks like we have a request for to set aside the referee's recommendation, and then we have a objection to the referee's recommendation. I believe that's all the same thing. From the plaintiffs. So let me hear from the plaintiffs first, and then we'll hear from the defense, and then we'll see where we go from there.
Yes, Your Honor. Thank you. We are requesting a de novo hearing pursuant to MCR 3.215. Under that court rule, the court may conduct a hearing, take additional evidence, or order that the referee conduct a further hearing when necessary to properly decide the issues, and that's what we think is going on here in this case. The referee's recommendation rests on materially incomplete record, particularly as it relates to the child's school placement, which, as we all know, is a significant joint legal custody issue that directly implicates multiple best interest factors.
Let me interrupt you for just a second. I think that there's two steps to this process. One is that there was already an order entered adopting the referee's recommendation. Is that correct?
That is correct, Your Honor.
So you're asking me to set that aside based on some service issues that you had trying to get that objection here in a timely manner. Is that correct?
That is correct, Your Honor. And just for additional context, I think I even misspoke in my motion for reconsideration in that I believe I indicated that we gave opposing counsel notice on the 16th prior to the deadline. She was actually given notice on the 15th. We did overnight our objection to get to the court the next morning, and apparently did not get there until the day after the deadline. That's our own deal with UPS and as to why that occurred. But we would argue that certainly Dad has not been prejudiced by this delay. I think that's even more evident in the fact that he was able to file a response to our objection. So as far as I'm aware, because it was never brought up to me, I didn't notice that this was late until we got the signed order through a records request that we realized that there was a problem. So we would argue that nobody's been prejudiced by the delay. We're here today. And we would ask that, based on the reasons outlined in our motion, that the court could constitute the delay as an excusable mistake or neglect, however you want to word it. But I don't feel disposing of the objection and request for a de novo serves the children's best interest just because of a technicality.
All right. As to that limited motion to set aside the order based on the service issue, defense counsel, your response?
Well, Your Honor, I don't have that. Well, I see it now because my assistant brought it in because in my mail this morning, this motion to set aside, I see at the bottom of his cover letter, he says he emailed it to me I presume November 5th, the date of his cover letter. I did not receive that via email. So I have not even reviewed his motion to set aside. I am aware that he is making that request. My position is, I see it in his motion now that he states his client retained him a couple days prior to the objection period. This is kind of her MO in this type of case. It's happened in motions before where she is not timely. She withdraws the motions after my client spends significant fees defending them. And so my position is that the court should uphold their order and that it wasn't filed timely.
Your Honor, if I may offer some quick insight, I also don't know the veracity of the truth as to what counsel just stated regarding, prior filings are being withdrawn. I will point out that even when I look at the register of actions, my client had less than 7 days notice for this evidentiary hearing. It doesn't even look like for this February or September 15th hearing, the actual notice of hearing was not prepared until September 9th. So procedurally, I think my client was at a disadvantage. I think that pertains both to this issue as well as the request for the de novo. But nonetheless, I do not think that dismissing this based on a technicality serves the child's best interest in any way, shape, or form. And we're here. I do not know why we would not just continue as planned.
All right, I'm going to agree to set aside the order adopting the referee's recommendation because I do believe that plaintiff's counsel had an answer ready prior to had an objection ready prior to the expiration of the time period, but there was an issue with overnight mail, which he has documented in his motion that appears to me to be while he was skating very close to the edge as far as the time limit, he did take action, substantial action within the time limit that normally would have gotten the objection to the court within the normal time period. It was but for the court's efficiency where I entered the order on the first day that it was possible to enter that order. In most courts and quite frankly, in this court, normally it would have taken a couple of days and the documentation would have been here in a timely manner. So for those reasons, the procedural technicality of it, I am going to grant the request to set aside the order adopting the referee's recommendation and find that the objection was timely entered, which brings us to, so counsel, if you would, plaintiff's counsel, if you would prepare an order that grants that motion for my signature, I would appreciate that. And then that brings us to today, where there is the request for a de novo hearing. So I'll hear argument on whether or not we should have a de novo hearing, and then we'll set, if that's granted, we'll set a time in the future for the actual argument. And because I've not had a chance to review the referee's CD or the video of that yet. So we'll hear some argument on whether or not we should have a de novo hearing. So I'll allow plaintiff now to argue that motion. Go ahead, sir.
Thank you, Your Honor. As I was just mentioning, this hearing was originally scheduled for October 15th, the referee evidentiary hearing. And then suddenly, I believe my client got notice on September 8th that the hearing was now being moved up to September 15th. The notice for that hearing was actually prepared on September 9th. And I think that leaves her at a severe disadvantage. She did try to get officials from both schools as well as other witnesses to appear for that hearing. Of course, she is not an attorney. I understand that she didn't know how to subpoena these witnesses, but I must say, even if I had 6 days notice of a hearing, I think it would be very difficult for me to get witnesses subpoenaed for an evidentiary hearing on such short turnaround. So with that, I think immediately she was at a disadvantage for this hearing. And first of all, the referee did not hear, because of this, testimony from any personnel at the child's school, the prior school or the current school. Yet these are the individuals who teach, evaluate, and observe this child daily. It's not just based on subjective opinions of the parties. And we believe that these witnesses would have central facts under several best interest factors, particularly B, H, and J. Without that testimony, the referee clearly lacks a complete evidentiary basis to assess the child's schooling needs and whether or not the current school versus the prior school, you know, who is better equipped to accommodate the child. Not to mention, the referee didn't hear any testimony regarding other options as well, such as other schools, homeschooling, whatever else there could be. I think it's also important to note that this objection appeared, or the recommendation, Your Honor, appears to be more heavily focused on sanction driven regarding my client and her procedural deficiencies in going about this, rather than what's actually in the child's best interest. So we believe that the Michigan courts have recognized that this de novo process exists to ensure that the judge and the referee can make the ultimate decision on contested issues based on a complete record, and that the court uses the de novo hearing to receive additional evidence where the referee's record does not adequately address the child's best interest. And that's what we think is going on here. We don't believe that this is a minor issue. The school placement is significant. It affects the child's stability, daily routine, connections, access to academic supports, which I think is clearly controlling in this case, simply because this child does have an IEP. And this kind of decision of this magnitude should not rest on a partially complete record. We are not asking the court to rehear this matter. We're not asking the court to relitigate. We're just asking to supplement additional testimony so that this court can make a proper decision in the child's best interest. At the end of the day, Your Honor, I think the process here was procedurally deficient itself, in the fact that there was such short notice for my client to gather these witnesses for this hearing. And we would just ask that this court either send this case back to the referee in order to conduct some supplemental testimony, or this court can hear that on a de novo hearing. But we would ask that this court allow my client to present that evidence and testimony.
Defense counsel?
Thank you, Your Honor. First, I rely on all of the arguments set forth in my response to plaintiff's objection. The fact of the matter is Ms. Rollins failed to properly prepare for what was a 3-hour evidentiary hearing. She can claim all she wants that she didn't have time to prepare, but my client had the same amount of time. She filed to my office 3 days before the evidentiary hearing a list of proposed exhibits and witnesses. She failed to call witnesses. She failed to and I will disclaim my colleague did handle the evidentiary hearing. So to my knowledge, she did not submit any evidence at the evidentiary hearing. She could have raised procedural issues at that time or timeliness issues, and that was not done. In fact, now she's retained counsel just days before the deadline. And as we just went over, had issues getting an objection in timely. And now she does want to relitigate this whole case. Her whole 60-some paragraph objection sets forth what evidence she will present, what witnesses she would like to call. All of that would have been available and was available to her at the evidentiary hearing. She filed an ex parte motion trying to change the child's school. It was denied. My client did the same thing to try to prevent the change of school. That was denied. And there were several hearings noticed. My office had to call the court numerous times to make sure we were prepared and that what was noticed was actually what was happening that day. She could have done the exact same thing and failed to do so. The fact that she was underprepared for, again, what was a 3-hour evidentiary hearing, it would be prejudicial to my client if this court allowed another full-blown evidentiary hearing. Pursuant to MCR 3.215 F2, this court does have discretion to limit witnesses and exhibits that were available to her at the time of the evidentiary hearing. Frankly, I don't think a de novo hearing should be granted at all in this case, but if one is, I would request that they are limited to new evidence available after the evidentiary hearing, which frankly will only be detrimental to her because the child is not doing well in his current school. I also do want to point out that she continues to violate this court's order despite the referee's recommendation admonishing her for saying, we are now going on 4 months of the child being in a choice of school of her choice only that only benefits her. The child, again, is doing extremely poorly, and for sake of arguing against my own argument of bringing up new evidence, this cannot continue to go on. We have a show cause motion pending, and I believe sanctions should be granted against her, and the child should immediately be replaced in Gaylord Community Schools.
May I have a brief response? Yes, thank you, Your Honor. So first of all, I would caution the court as to allowing counsel to provide facts that have not been proven or testified to regarding how the child is currently doing. I will say that I think it's even more concerning that neither one of these parties actually reside in this district anymore. I can't even sit here and say today that this child could even be allowed back into the Gaylord School District. My client has sold her home, and it's not just as simple as, well, it's in this child's best interest that we limit this witness testimony. This court's job is to determine what is actually in this child's best interest. And the only way they can do that is to get a full record to review. I would say that these witnesses weren't available on such short notice, and I do not think any witnesses should be limited. I don't think that my goal here is not to have cumulative testimony. It's not to put my client back on the stand to testify to what she already did, but it would be my intent to take a few hours to get the people in here, and maybe the court's opinion changes, maybe it doesn't. But I think by giving my client less than 7 days notice for this hearing did put her at a disadvantage. I do think that's a violation of her due process. And at the end of the day, we don't feel in any way, shape, or form that any of this is to serve the best interest of the child rather than just sanction my client.
May I respond, Your Honor?
No. How is it that your client, plaintiff's counsel, didn't have notice, didn't have preparation time when she didn't bring the issue of changing schools to the court's attention until the end of August? How is it that she would not have proper notice that a hearing would be required and that witnesses and school information would be necessary when she waited until August the 28th to even file a first motion regarding changing school systems beginning the next weekend or after the next weekend, after the Labor Day weekend? So
Yes,
how
sir.
is it that she did not have sufficient time to file a motion and gather the witnesses and evidence that she needed during the entire length of the summer preceding her motion?
And I think that's a fair question, Your Honor. I think that just lends questions to the timeline here. My understanding is that my client had discussed this with the opposing party, and it wasn't until the end of summer that he indicated he wasn't okay with this arrangement. That's my understanding. And at that point, she was well underway of already. I mean, obviously, she had to take steps to get this child into this school ahead of that filing. It wasn't until it was clear that he wasn't actually agreeing to anything and that this was a legitimate problem and that she learned what the process was that she did file that motion. And from when I look at it, it was kind of a messy start to the case, and the fact that there were several ex partes filed. The best procedure probably wasn't followed here, and hindsight is 2020. But nonetheless, I think that's still different. She filed the motion. I can't even say if she knew who the teachers were at the new school at the time that she filed that motion. But even then, in my experience with these school officials, they're not going to show up unless they do have a subpoena, and you get that advice from their counsel. So she filed this on the 28th, and then there was a hearing on the 15th. I still think there was no way for her to know when a hearing would actually be scheduled, especially since the original notice was for October 15th and then got pushed up a month. So that was just kind of unusual, I think, with the timing.
It was unusual because the court wanted to make a decision before the child was in school for any length of time, which is how that decision is supposed to be made. It's supposed to not jerk a child out of a school system and bounce it back and forth. And the court had no way of knowing which way the case was going to go. So we set it as early as possible so that we could make a decision that would not unfairly jerk the child around if a decision to the contrary was made. I think the court did everything in its power to make amends for the mess that the plaintiff created. We tried to have a hearing as quickly as possible so that neither side was prejudiced and the child was not clearly prejudiced by moving school districts. She's the one who made the unilateral decision to move the school districts without prior court intervention, which is something that just simply should not be done, period. She did it. She bears the consequences of that decision. And the consequence is there was a shorter timeline. That's not the court's fault, and it's not the defendant's fault. She had every time to gather the evidence during the summer. She didn't make a decision to go over to the Traverse City area or the Forest Schools area on August the 28th. She had that decision made many weeks in advance of that. So she's had plenty of time, in my view, to gather that evidence and to have those witnesses available ahead of time. The fact that she waited until the last minute to gather the evidence is nobody's fault but her own. So no, I under the statute, I'm not going to give her the ability to call witnesses that she could have had previously. NCL 552.507, subsection B, subsection 6 says that a de novo hearing includes a new decision based entirely on the record of previous hearing, including any documentation submitted there. And that's what we're going to do. I'm going to make it on the information that was available to the referee at that time. The court has the discretion under that statute to prohibit the party from presenting evidence that was not objected to determine the referee's finding conclusive as to any fact that was not objected to, and to prohibit the introduction of new evidence or use of new witnesses absent showing that the evidence was not available at the referee hearing. I believe that that evidence was available at the prior referee hearing for all the reasons I've stated on the record. So I will grant your request for a de novo review. I will make that de novo review based on the information previously provided to the referee, and I'll issue my written opinion as quickly as possible thereafter. Defense counsel, if you prepare that second order with that ruling, I appreciate it. Is there anything else that we need to do today, counsel?
I don't believe so, Your Honor.
Thank you very much. That's all then.
Thank you, Your Honor.
Okay. Hello. And are you still at 9235?
Yes.
That's okay. And you are charged with the third-degree felony of theft, which carries with it up to 10 years in prison and a fine up to $10,000. Very serious. So you have to fix this, okay? Fix it and work with your attorney. I'm sure she is going to help you well here. Did we have a loss on this? Is there a loss to the victim? Do we know? Is there a loss?
As far as I know, there's no.
Unfortunately, there's no loss to the entity.
Yeah.
Because restitution is very important if it is. Okay. So what apparently they said the victim had already provided the male, the defendant with $20,000. What about that? Is that an amount that it says he attempted to withdraw $30,000? The victim had already provided the defendant with 20,000. So this is showing that they've already, you know.
This is Mr. Ham's case. Yes, I'm looking at here, Your Honor. It says the amount of loss was $20,000, and
That's what they're saying.
It said they did not have insurance.
Did you know that?
I'm not get the evidence, so I.
Well, you're going to do that pretty quickly. It was indicted. little over a month ago, so are you going to work with the state here to try to get as much information as you can?
Yes, Your Honor.
Okay, you're gonna need some time to do that. I'm gonna give you 4 weeks I'm gonna reset this 4 weeks to see where we are on this, okay?
Thank you.
And you are out of Austin,
Yes, Your Honor.
correct? All right, are there any issues need to be brought up right now?
No, Your Honor.
Okay, so get a resetting here for 4 weeks, okay? Thank you. Yes, ma'am.
Thank you.
Taylor Jackson. Taylor Jackson.
Sorry.
Yeah.
Sorry.
Yes, and I would do the certifications.
All right. Next, we call 24 CR 2260, the state of Texas versus Taylor Levette Jackson. You are Mr. Jackson,
Yes, sir.
and you were here with Mr. Lang, your attorney, and the state's attorney is here. All right, we are here on an announcement, five cases total, is that right?
Yes, sir.
Okay, are they all similar allegations?
With the exception of one, one is a unauthorized use of a motor vehicle and the others are accidental, so.
It looks like 4 cases of sexual assault of a child was carved out of 2 events,
Yes, sir.
December 11th and December 14th.
Right, as juveniles. And then certifications, and some of the announcements have been to retain the certification material. I have been there, I've talked with Mr. Nelson, and I think we're satisfied that there's a proper certification. If I could have one more announcement to give with Ms. Moore, then we could see where we're headed.
Right, the other case is a separate
Unauthorized use of a motor
unauthorized use of motor vehicle.
That-
hold on. Right. He was indicted on October 30th of
Yes.
2024. What took so long?
Well, it was a grand jury indictment. Nobody knew the warrant was issued. And when he got arrested for the unauthorized use, that was when he realized that there was even an indictment for something that he did 9 years ago as a juvenile. And so that's how.
Well, they still count
Well,
when they're sexual assaults on children.
yes, but that's how he understood their movement. He did. That's why it's the way it is. That timeless.
Hold on, just a second. While I am waiting to receive some information here,
Yes, sir.
each of these are first degree felonies. except for the unauthorized use of a motor vehicle, which is a state jail felony. So you got 4 cases where you're looking at life, up at the life in prison on each case. Do you understand how serious this is?
Yes, sir.
4 life sentences, which could be stacked. Theoretically. Then the state jail felony carries with it up to 2 years in the state jail. Look at one thing. Brian, how's the family? Everybody well over there? That's the best we can hope for.
Kevin, Shirley's been in her house. I've had all the bouts with my in-laws, in and out of the hospital.
The what are the dates on the bonds on the sexual assaults? Does it show? Place?
Absolutely.
What were the bonds on the sexual assaults? Was that on the same day? Something, you know. You're giving me 9/20/24, but I'm looking at a bond on May of this year. On that. Oh, for this unauthorized use of a motor vehicle, I guess, huh?
Yes, sir.
He was arrested 9/20/24 on all of the cases.
On all the cases.
And he bonded out 5/28/25.
Okay, even,
Sorry. I just wanted to last.
I mean, it's, he got arrested when they arrested him for the unauthorized use of a motor vehicle.
Yes, sir.
And then those other cases had been pending, and then they all collapsed on it.
And then they took him to a certification hearing prior to getting released.
What are your bonds on these aggravated sexual assaults of a child?
They're very
What are
high.
they?
Yes, sir. They
How
were
much?
100,000 apiece.
Yeah, I'm confirming that, Judge.
Who paid for that?
My father.
You know, this is your responsibility. You understand all of this,
Yes, sir. Yes, sir.
not your daddy's. This is yours responsibility. Welcome to the real world and grown up adulthood. And all of us, when we make a mistake, we've got to handle it responsibly. Are you going to do that?
Yes, sir.
Well, Mr. Lane's a very good lawyer. He can help and guide you through this, but these are most serious crimes. Juries in this county deal with them severely.
Judge, incorrect in that the bond is $100,000 on sexual assault cases, and on the unauthorized use, the bond is $6,000.
The one of the conditions of bond is that you cannot have contact with a victim of an offense. And with you, I'm adding a condition of bond. You're not to be around a child without alone, without some kind of chaperone of an adult. You understand?
Yes.
You're talking about children who are 6 and 7 years old. That would be an added condition of bond.
Yes, sir.
One error on these types of cases for a bond, and your bond will be revoked, and you will sit this out in jail until this can get resolved. There's hardly a more serious crime in the penal code than this. You understand? Okay, how much time, Brian, do you want on an announcement? 5, 6 weeks?
Yes, sir.
Is that good? Okay. All right, please get a resetting.
Thank you.
And also you, sir, come on up, you gotta get resetting. And also you nor anyone on your behalf can have any contact with these victims. Do you understand? You or anyone, if I find out that someone is talking to them or the parents of these, you need my permission. And the lawyers have to do their job in investigating, but I don't want children who are victimized to be re-victimized or manipulated during an investigation until all of this can get completed. All right, Arnie Koenig. As you? Yes, sir. Right, you're here with Mr. Wayne. You were charged with burglary of a building. Which would otherwise be a state jail felony, except you got, well, 2 other state jail felony convictions. In 2017 and 2021 out of Liberty County, Texas. Does that affect the punishment range on these?
Yes, sir.
Do it. So the state jail felony that would otherwise be up to 2 years in the state jail because of these prior convictions. This kicks up the potential punishment range to what would be a 3rd-degree felony range up to 10 years in prison. We are all responsible in crimes. When crime is committed, every person charged with the crime is subject to the result of the circumstances of the crime and criminal history. Those are the 2 parts of the equation that are part of the criminal system in dispositions of how somebody gets dealt with and the punishment. What are we going to do today, Brian?
Well, we've gone through a couple.
It was an announcement to that for today.
It was an announcement today. I tried to set up.
It's been a year since he was indicted.
Well, I've gone through a couple different prosecutors. At this point, we could set it on.
That's not unusual.
But I tried to give it this gas ball, but if the court, right now.
What do you want to do?
We're at an impasse. Right now, we'll put on the trial.
Sit on trial, sit the trial. That's all language to get.
Well, I like to talk. I'm a talker.
Everybody likes to talk, but you need to say something
I gotta say something.
when you're doing that. Randy Johnson.
Mama holiday.
Yeah. Yeah, I'm right in the back. All right. Today, a status hearing is what we had planned. And the defendant, you are Randy James Johnson?
Yes.
Mr. West is here. Mr. Minaldi is your attorney. You don't object to him being here with you, right? Is that okay? Look, when you come to court, dress, would you wear that at church? Why not?
I'm sorry.
Well, but nonetheless, yeah, you leave a shirt in the car or something so that you can put it so it's decent. That's not proper.
Honestly.
You know, And it just shows that this isn't, you don't have much respect for the whole process here. That's what this shows. And you should be, it's your liberty at stake. You're looking at up to 2 years confinement in a state jail. Okay, so he pleaded true back in June of this year. And what did you do on this? Did we can just continue him on probation? All right.
Make some progress.
Okay, so on behalf of probation, let's get to the bottom line. Good news or bad news? Okay, that changes the directions we were headed in here this morning. Go ahead.
He has completed one of the courses that he was required to
How many does he have?
do. There are two.
When are you going to complete number 2?
I get paid on Thursday and I'm gonna start on the day.
How long does that take?
It is the 32-hour course, so it can take some time. And then there was the theft class, and he did complete that one.
I'm sorry.
The theft class, and he did complete that.
Good. What'd you learn?
Yes.
Give me an example.
Like with the theft, what I'm being charged for, like, I could have went in different ways instead of just ringing in the street. I could have called, involved more people, speak up, said, do different things instead of trying to take it into my own hands and doing it.
I know you're talking about, you use I a lot, but there's a victim here. In crimes, they're victims. And what about that? I mean, do you regret causing harm to someone? When it's a theft, generally it's a loss of something of value that they have, that they acquired, that they work for. Just like me grabbing for your wallet and taking it and I say, it's mine now. You'd feel victimized, which you should, because you worked off for it. It's sweat equity that you can't get back. And the sweat equity was in something that you acquired. You see, sometimes it's materialistic, sometimes it's there are other forms of reward, but those are things that you can't get back again because you've already put the effort in. You'd have to duplicate it, which we only have about 80 years on the planet. So we don't have time to pay for the same real estate twice. You know what I mean? And that's the way it is for victims. So was there any restitution on this one? I'm always sensitive about that.
Yes. There was restitution.
Is there anything left?
Yes.
I don't like that. You've been on probation now for 1.5 years. How much is restitution?
1,500 in total, 1,350 is left.
You only paid $150 in a 1.5 years?
Wasn't working at first.
How are you now?
I'm working.
Well, how much can you pay toward this I wanted to go for restitution, please, first, and then we'll catch up on the other stuff. I can shorten probation for good behavior, but good behavior includes paying victims back. It would cost you less if you get it done quickly. Then we could, all things being the same, if you're doing fine, then I shorten it all. But I shorten probations I can do it in 1/3 of the time. Like for 5 years, 1 year and 2/3, I can shorten it, which in your case would be almost there if you were doing everything fine. But until you can pay this victim off and take care of the other obligations on probation, then you're going to be dealing with me. What else do we need to do today? I want to know on the restitution, how much can you pay back a month? How much can you pay a month toward restitution? Right now?
Thursday, I will be able to.
No, I'm talking about long term, not just, you've got a regular job, right?
Yes, sir.
Oh, okay, I'm talking about how much can you pay a month? So restitution and then pay your bills.
at least trying to balance everything, I can do 3.
Sir,
300. Do 300, they just.
Okay, well, here's what I'm gonna do is order you to pay 200. Meet that goal. Because, and what's left?
13.
All right, so that's 6.5 months.
Yes.
State champion in number sense, when I was honest. Should have been an engineer, but no, I went into law. Okay. So I want to review this in 4 months. See how he's doing? Is that good? Anything you need to know about or ask so that you can complete your probation successfully? Okay, well, just get it done. Okay, so any problems come up, she's your guiding, you get lost in the woods. A lot of people do on probation. They're about to make the wrong choice. She's your lifeline. You call her, you get advice. She'll guide you out of the problem. Don't delay if there's an issue. Resolve it. Right. Thank you. Shane Myers. Okay.
I'm gonna give you a copy.
Shane Myers.
That's what it said.
I believe all of the cases that we said, Your Honor.
Shane Myers has been reset according to my boss. That's 3 cases. It's reset for what, though? It's
It's located on the docket, but there's a 3rd amended TRP that's on the way, so.
okay. When did we reset it to? Because I don't want to go, when we modify, that means something bad happened that we need to address. Norman Marshall is next.
The first week of January, the defendant is in custody though.
Okay, the attorney knows that. Reagan, I guess, knows that.
Yes, correct.
Are you Norman Marshall?
Yes, sir.
This is about restitution. Who's on?
I
filed a motion to dismiss. Oh, you got it? Oh, okay.
Yeah, here, Mr. Patches said.
You paid it off?
It was paid.
Yes, sir. The ticket,
Good for you.
receipts right here, you can see it.
No, your word's good enough for me, sir.
Thank you.
And I got a motion that's right here to dismiss for fixing the mess. That case is gone. It's dismissed. Go and do well.
Do I get a piece of paper saying that?
Well, yeah, we can get you a parting gift like that, no problem.
Okay.
The best thing, though, is she's not, the best thing, we're gonna have to get it through the district clerk.
You're gonna mail it, will you mail me something or?
We won't mail it.
She's gotta prepare it first,
Right, I understand.
and it takes
Yeah.
a day.
So it goes over to the district clerk's office. That's where you can get a copy. So
Will they email me a copy or something? I'm 5 hours away.
Yeah, we can take care of it.
Or I can email to James or something.
you can speak to the ladies across the way.
Okay.
And they can tell you how that.
Okay, James can probably take care of it
If
for me.
there's a problem, call us, and then you'll
Yes.
get something wired to you somehow. You don't need to.
Okay.
drive it.
Right.
Yes, sir.
Thank you, Joe.
Okay, yes, sir. Rebecca McWhorter,
That was first said.
how are we gonna get things done? If we reset them? I'm just asking. Nakia Washington? That's reset?
No, that's fine. Your Honor, Mr. Rank's listed on there, but not code. Okay, so I'm also. I would say I'm playing Mr. Riddick, but I'm actually playing this.
Good morning. I'm fine.
Yeah. Not volunteer.
You're Nakia Washington?
Yes, sir.
And here with Mr. West, your attorney today, the state's attorney and the probation officer here. We have a first amended motion to revoke probation that had been filed a year ago, correct? Is that the most recent thing?
Yes, Your Honor. I believe so.
And something doesn't make any sense. On first amended motion, I've got that pleas of true were entered on paragraphs 2 and 3.
And 8, I believe.
Hold on. But I have that dated 6/17/21.
Should have been 6/17/25.
25 of the, okay. Okay. And I'm going, why in the world, what's 21 all about? And that's when the motion was filed on 6/21, the original motion. And we must have been talking about that when I was doing the writing. So on 6/17/25. Correct?
Sorry, Judge.
All right. And, okay, on the next page, I've got 6/17/25. Why 21 got in my mind? And these were a specimen result, and it came back with marijuana, and then failing to report online. So how are we doing, Ms. Martinez?
Your Honor, she has the reporting and she paid all of the restitution off.
Oh, that's great. So she's been on probation since when? 19? Since April 19? And that was $2,033 restitution, correct? And this has been a deferred or unadjudicated probation, correct? The whole time?
Correct.
We've had her on probation for, let's see,
5 years originally.
5 years, and it's been 5 years. So what can we do today? What do you think?
Well,
Don't help her. She's gonna, is it?
she's good. Yes, sir.
Okay. Any objection to me dismissing this case and her moving on with her life without a conviction?
You do it on my signature,
Then
yeah.
so it shall be done. Okay. Good luck. Good luck and good work. Thank you.
I'll need an NPRB this.
Huh?
I'll need an NPRB this.
Oh, no, he said he was doing it. I'm considering it.
On Willie Coward.
I am.
93% or successful on probation. That's the probation office's rate, which is a little better than the 75% national rate. A lot better, actually. Must be some great probation officers that are working for us here in this county. That's all I can say. All right, here we are on Mr. Coward. And he was on probation. He's been on probation a while too, since 2019. And this was a theft case. And there was restitution at the beginning of $4,280. Well, I hope that is dwindled to nothing.
Mr. Cowart was actually incarcerated for the first about 5 years of probation. He was actually paroled in April of 2023. For a brief moment.
What was he in prison for? It must be another case.
It was a Orange County and Hardin County case, I believe. And then
Of what? What was the crime?
Failure to register.
As a sex offender? Okay. What else?
He had a blue warrant issued and his parole was revoked and he went back to prison for that. And then we had a motion to revoke on him after he was completed that sentence. He was released and opted to not comply back in 2023. Once he completed his sentence in TDCJ, he was served our warrant, which brought him into our custody.
Okay.
He had sent correspondence to the court requesting revocation to run those cases concurrent. At that point in time, you opted.
Restitution.
Yes, you opted to allow him the opportunity to perform on probation because of the restitution. Mr. Cowart has been reporting to me directly since you released him from custody. He has paid $711 toward his restitution. He does have some medical issues. He completed a substance abuse evaluation because during those meetings, he has tested positive on 2 occasions, which we were able to obtain some medical records in which he was prescribed a medication that would cause a false positive of opiate, but not for the methamphetamine. And then he also had tested negative and then followed it up with a positive for methadone. Mr. Cowart and I have had many discussions about those uses in which he does admit to those drug usage. And we're here today for the follow-up review of the motion to revoke.
And this motion to revoke probation was motion filed August of 23, over 2 years ago. But we ended up having a final hearing on it June this year, where you pleaded true to failing to report to the probation office, and it looks like on a couple of different occasions. And the court continued you on this probation. And in all cases of theft-related matters where there is a loss to the victim, unlike if you broke their arm, you can't unbreak it, but you can pay people back. So there's a method. The only problem is the longer you pay them back, under the law, unlike this federal system, where they compound interest for delay of repayment on fees and costs and restitution. Here in the state, it is not interest based, so it's dollar for dollar. If you are in this, like in this case, it's been 6 years since this event. According to the indictment, this happened in September of 2019, and we're still paying these people back. And you really hadn't paid, but how much?
$711
Out of
$4,280.12.
Okay, that's 1/6. That's 16%. That's it.
So it's incorporated, so.
I understand, but you're not incarcerated now.
Yes.
How long have you been a free man? Don't look at him.
Probably 6, 7 months, or I'm not.
You got a job now?
Walking on, yes,
What are you doing?
whatever I can.
Okay. What are you trying to do? I mean, what skills do you have that you can market?
Well, I was bad with this scrapping sometimes. Sometimes I do some house framing. Sometimes I do tree work, and it just really depends.
Yes,
on
Okay, well, there's a lot of building going on in the area. Maybe you can hook up with somebody for regular business. Are you good at what you do? You're hesitating. Most people jump right out with it. You bet.
I've got a lot of medical issues that keep me from being, peak performance. So,
Right. This probation, even though you do everything great, this probation is going to continue as long as it takes to get the people paid back.
I can actually pay them back today with the help of my brother and what I have established. It can be paid today.
The whole balance?
Yes, sir, but my brother is not willing to go there, not have an opportunity to go back to prison. So this, if it just didn't make no sense to him, I understand he's going and not being able.
Okay, hold on for a second. Here's another thing that this court, you don't hold me hostage.
No.
You don't negotiate with me.
No.
That's not these are the negotiators, not me.
Yes.
I just make the rulings.
Okay.
And anybody who says, look, if you don't do this, then this is what's gonna happen, Judge. No, that doesn't work with me.
Yeah.
I don't tolerate that. Everything is a leap of faith. But it's the right thing to do, and it's what you're obligated to do. And I will promise that I will do what it takes to be fair and impartial. But you don't say, here's the deal. Somebody tried that earlier this week. And I shut that down pretty quickly, because that's not the way you deal with a judge. It's a leap of faith, but it's the right thing to do. And I've been doing this long enough. People know what I'm going to do. I'm going to handle it. You get rewarded by getting victims paid back. Period. That's what I've always done. I'm not going to change that. But you don't make a deal. It's a leap of faith. So what else are we? He's been on this now for 6 years. What else? Let's say restitution is paid back. What else are we looking at here that we need him to continue to perform on probation for? Gina,
Well, Your Honor.
you're an expert. Whatever you say, she's one of the best in the business. So
Well, thank you.
she's got to tell, she knows the right answers on this, and that's why I rely on this probation office, because I trust what they do. So where are we? He pays the restitution. What other obligations does he have? He's got, of course, a period of time still left on the total probation, but we shorten probations when it's worthy. What else does he need to, what other obligations does he have left to perform?
Your Honor, the concern obviously is going to be the substance abuse. We did complete a substance abuse evaluation in which a recommendation was made for special needs Tepe. However, because of the fact he is a registered sex offender, he's ineligible for that placement. We have the option of ISF. Even I would ask the court, because of the amount of restitution that is owed, Mr. Calvert does actually live in Vidor, but that we asked the court to make him report directly to Jefferson County if they're willing to continue him on supervision. That way we have a closer eye and to ensure that our restitution is paid to our victims, as well as we could possibly include JCDI, but then JCDI puts a burden of an additional financial burden along with transportation burden.
Yeah, I'm not applying for that, right?
Or we can just continue to monitor the substance abuse usage with putting him on colors, or we could just monitor him with a monthly drug test.
We have
That's the
options.
problem. It's obvious what we're talking about here. We're more concerned about you falling backwards on the drug situation. And monitoring, keeping a close eye is a good deterrent, because shame on you if you fail. But you gotta figure, you gotta realize this is in your best interest. This is only good for you, not bad.
And Your Honor, the other thing that he had as a special condition would be the community service, but I do have medical records from his current physician that is prescribing the medications out of Houston that could possibly result in a waiver of the community service because of medical.
Okay, see, we're looking for things to reward you for. My advice, if restitution could get paid back, that makes a big difference where this heads. And also, there might be a method where if we need to continue you on probation, it's less high maintenance. It's more of a relaxed form of probation if we can trust you. And but it's obvious that there's going to be, and you got to look at this. You got to realize it. We will continue to test, which is a deterrent. Shame on you if you positive test, but that's what it has to be. And you can't say shucks, because it's our test. We're paying for it, really, but it's your best interest. We want to make sure if you're falling backwards on drugs, that we catch it fast. But it's your choice. You do the right choice, you shouldn't have anything to worry about. You make the right choice. So what are you going to do? We're going to right now. We're going to continue for the time being you on probation. I want to review it in 6 months, though, how we're doing. But once again, if restitution can get, if you're able to have resources to pay this restitution, I'm telling you, everybody knows that goes a long way with me. The quicker they get paid back, the quicker I'm happy, and I will reward. I always do. And you may have to continue on probation for a while longer, but it will be a more relaxed form of probation that if we can trust.
We're going to order him to report to Jefferson County directly instead of, was he reporting Orange County?
No,
Yes.
he's been reporting to us because of
I think it's probably closer to him here than it is over to Orange County, to Orange. So why don't we do that? That'll save you a little gas anyway. Report directly here to Jeannie and the probation office, and get this. I want to know when this restitution gets paid, so I can look at relaxing other kinds of terms of probation that are unnecessary, that are normal, but they're unnecessary so that you're more free to work and be independent. Okay, let me know. Thank you.
Yes, sir.
Right. 6. Leslie Kettery.
I'm on the highlighted X for right there.
That's one thing I have. Some of guys speak. That's it.
Leslie Kettery. See those times? I don't think so. She's absconding.
We'll go find her.
All right. 22-40038 is called the state of Texas versus Leslie Roylene Kettery. There is no answer here in the courtroom, and I'm going to ask the bailiff to call into the hall for Leslie Kettery. There is a first amended motion to revoke probation that was pending in this case. It was filed October 2nd, and it alleges a lot, 12 separate violations. And this There's no response to the name call here in the courtroom, no response to the name call into the hallway. The defendant has failed to appear. A warrant shall be issued. Stand by. For her arrest. And this is regular probation. She is convicted. There is no bond. We will deal with it when she is placed in custody. And she is, because this is regular probation, she has been convicted of the felony, sentenced to 2 years in the state jail. And among other conditions, it's like we've had a hearing earlier this year in January where she pleaded true to assault, failing to report, and providing a urine sample that showed a cluster of drugs in her system. And here, this first amended motion has added to the problem with failing to report. Has she failed since June?
Her next report day was in July 11th.
Okay. Because apparently illegally possessed methamphetamine, failed to submit alcohol and drug screening, attempted to provide a false specimen on July 11th. Somebody else's urine, is that what it was?
Yes, sir.
And then failing to pay court-assessed fees. Well, it's really clear that this drug problem, mainly methamphetamine, the devil is on her back and she's having a hard time getting off of that and becoming independent. And that's, she's free falling. And hopefully she'll get arrested before something terrible happens to her physically. And then we can help her, but there will be a warrant and no bond. Next, Ryan, is it Leaks or Liax?
Yes.
Ryan Taylor Leax, Leax. On this one?
No, sir.
Yeah, we'll do it next. Well, Skip.
Well, I think I went outside. We're going to say, right after Mr. Cody.
Yes.
What's his name?
Preston Lake Sandy.
Okay.
Over here.
Okay, on Ryan Leax? No answer? Oh, boy.
Easy days.
We've got-
None of them showed up.
Well, there are ways of dealing with this. It looks like we have two cases on Ryan Leax, correct? 24 CR 1178, where he is on probation for burglary of a building since September 16th of 2024, and that's for 10 years probation. And also on that same day, there is a second case of burglary of a building for which he was placed on probation for 10 years. A motion, well, we did with
This is already.
these motions
Yes. This is
back
statute.
in June.
A lot better.
And I guess I continued him on probation,
Yes.
but here we are. He's failed to appear. There is no answer here in the courtroom, no answer to that name being called into the hall. Ryan Taylor Leax.
What's up? Out of line.
What is his bonds?
He's not on bond. We sentenced him to a 30-day sanction and released him back to probation.
Okay.
He doesn't actually have any bond.
No response. The defendant has failed to appear. What was, he was noticed to appear by the probation officer?
He actually wants the bond.
He wants to be revoked.
Most of his time, I've only been with him twice, most of his time has been in at the mental hospital.
Yes, ma'am.
So, when he came last time, we had him sign a suicide prevention contract, spoke with him. And we reminded him that this is a court date, but.
Okay, well, the court is going to order a warrant for his arrest as an absconder here in probation. And the probation office had informed him he needed to be here today, correct? And he did not give you any reasons why he would not be. Okay. And then, so warrants are issued in each of these two cases, no bonds. Based upon the nature of these probations where he has been convicted and has now, when was the last time he reported? Okay, when was his next report date? Is he reporting monthly?
He was supposed to this.
Okay. Well, this month hadn't.
Supposed to be the 18th.
On the 18th, so he hadn't failed to come to this.
Not yet.
But you informed him to be here at this hearing.
Yes.
As a directive by the probation office. And he has failed to follow that directive.
Correct.
Okay, so a warrant shall be issued for his arrest based on a failure to comply with the probation office's directive. And there is no bond at this time. We'll deal with him when he gets arrested, okay? It's in both cases on Ryan Leax. Roland Wilkinson.
Your Honor, I was informed this morning that Mr. Wilkerson is in.
He's actually TDC now.
TDC.
Yeah, I looked it up this morning.
Okay. He's in custody.
He's been transferred to PDC, and so it's not to eventually to get him back right here.
That's the basis of the exclusion. At least some, I know there's probably
In
stuff.
two cases, 22-39212 and 22-39507, styled the state of Texas versus Roland Matthew Wilkinson. The defendant is on probation in each of these cases for theft of material, a state jail felony, and burglary of a building, a state jail felony, respectively, each of these numbered cases. He was placed on probation on May 22nd, 2023, as he was placed on deferred or unadjudicated probation in each case for 5 years. There is a first amended motion to revoke unadjudicated probation that has been filed recently, October 2nd. No, it was a year ago. October 2nd, a year ago, which alleges that he has failed to report in February through August and on September of 2024 for each case. Also, he was in arrears and payments. So the defendant had absconded. And I guess warrants had been issued for his arrest earlier.
Just he was in Orange County, and Orange County sent him to TDCJ. So
Thank them for alerting us so that we could bring him here. So what will happen is that we will get him transferred back here from prison to take care of these.
It's been a while.
Glad I showed up.
I appreciate the levity, gentlemen, but where are we at in this case?
Well,
Your Honor, go ahead, Mr. Fisher.
Oh, I'm sorry, John. I don't care either one.
See what I mean, Judge?
We have a business to sell, and that has been the impediment to getting this matter resolved. Most recently, the proposed buyer of the business obtained new legal counsel that has since prepared a purchase agreement that is being circulated. I would anticipate that we'll have a bottom line purchase agreement for the business within the next few weeks. And at that point, perhaps we can, Mr. Moodhart and I can at least pick up the pace as far as our discussions are concerned. And I think we have a pretty good idea of whether or not we'll be able to settle the property and spousal support issues that are in this file. So.
All right, Mr. Boudart.
Yeah, I agree, Your Honor. One thing Mr. Fisher didn't mention, just in way of excuses as to why this is taking so long, is that the buyers of the business actually had a different counsel, as Mr. Fisher alluded to, who had drafted a purchase agreement that was different in nature than the one that's currently being vetted. And we worked with that one for a while, and then they decided they wanted to change the whole thing. So it's just been a little bit of a challenge to get through that. And that is, I think, something that I'm not certain that it's that the sale of the business will fix everything, but it'll fix a lot of things. And so if we can get that completed, we'll have an easier time of it, Your Honor.
All right, I don't have an objection to what you're requesting. I think that the business sale is probably a very large piece of the puzzle. But let me just ask both counsel to do this. This case, I believe, was filed in December of last year. This is going to take us most likely, because of the holiday season, into 26, I would guess, before I get this resolved. I'm going to require the counsel to begin to lean on your clients a little bit more heavily to say this matter needs to be resolved. The judge is running out of patience. However you want to make me the bad guy, please do so. But I need to have this case resolved sooner rather than later. So how much time do you anticipate needing? We're looking at 30 days or 60 days. What amount of time do you think would be necessary, counsel?
45?
Mr. Moonlight?
Yeah, I mean, that sounds about right. I mean, that would take us pretty much to the end of the year. So sometime in the first week of January, perhaps we could come back and bring you the news, hopefully the good news.
All right, let me do that then. I'll have the clerk's office reset this matter for as close as they can to the beginning of January, and we will go there. I'm very much hoping that date can be used for the pro-con and we can resolve this matter. If we're not able to do that, I would like to have some detailed explanation from counsel as to what issues remain outstanding and your proposal for how to resolve those matters. And I would also like to have the parties present. Even if you don't have an agreement, I'd like to have the parties present so I can impress upon them myself the need for speed.
Understood, Your Honor. Thank you, Your Honor.
All right. Good to see both of you. If I don't see you between now and then, happy holidays.
Thank you, Your Honor. You as well.
Yes, sir. Have a good one.
Too. Written out to the parties, I would appreciate that.
Absolutely, sir.
Thank you very much.
You're welcome.
Judge will take care of that. She'll take care of
Okay. Next matter is Brooke Hewitt and Matthew Stalker, file 24-19949-DP.
Hewitt was here earlier. She's no longer, party's no longer.
All right, I believe this is a motion for default judgment from Mr. Rolla's office on a DP case. Is Mr. Rolla or one of his assistants with us?
They're not.
All right, there is a notice in the file from Mr. Rolla's office indicating Friday, November 14th at 10:30. It is now 11:43. Mr. Rolla has failed to appear. We'll reschedule that when he is available. There's a typo in the thing. Do I talk to Ms. DeFider about that, or are you gonna get a hold of Mr. Rolla for me?
I can.
Okay. You're gonna need to see that in a file report.
Yes.
You want me to leave it in the file, or do you want to have the Clement case in this file with it? If you,
Yes. Yeah, what you should do is just go through.
the issue is he wrote sole legal custody. It should be joint legal custody.
Okay.
But there's a notice, sticky note on it.
For the 657 in rent, and then of course the 198. 40.
What's the total?
Total is 855.40.
All right, Miss Epe, you apparently made a big dent on this. Do you think those numbers are accurate?
No, because I have paid my rent every month. I have a dog and my dog is EST certified and she's charging me for that.
I think they're allowed to.
I am charging her $2 a month for a pet.
Yeah, but I have proof that her and I talked before I even signed a lease. And she said that as long as I have paperwork saying they're certified, that I don't have a charge.
Well, what controls is what's in the lease, not what somebody told you. So let's take a look. I don't think there's an exception for ESA certified. A pet is still there. The pet is in the building. People have allergies. The pets are using the grounds. You have to pick up after them. So certified or not, there's a ramification to the complex. I don't think there's an exception. People want to have a horse, a mini horse or something as a certified animal, or a potbelly pig. The lease says, let's see if we can find the pet clause. Yeah, it lists your pet, the brown mix, 63 pounds.
The pet fee,
Pet policies. I'm sure the fee is.
I'm showing, Your Honor, under third page at the bottom, tenants shall pay
There it is, $30.
$30.
Yeah, it's in there. It's in the lease, and the lease controls as opposed to what someone told you. So you did a good job of getting caught up. You're really not very far behind now. Do you think you'll be able to pay this within 10 days?
No, because my rent is $1,000 a month and I paid all of that every month. I'm the only one that lives there and I'm the only one that pays all the bills and I barely make it.
I would offer, Your Honor, that I could do a conditional dismissal.
Are you gonna have to speak up? I'm not sure.
Yes. I could do a conditional dismissal, ma'am, which would allow you to pay this without a judgment, and I could put this out to the end of the month, which is, let's call it the 1st, because the 30th is a Sunday, so that gives you a little bit extra time.
Can't we push it out to where I get my taxes, then I can pay it off? Because
Well, they can agree to do that. They can give up to 56 days from today to.
But I don't have that authority to
ask for the writ. And then 56 days to serve it. But he can go till, of course, on December 1st, another month's rent is going to be due.
But it wouldn't be part of this case.
Yes. I'm just gonna do a traditional judgment. It's really not that bad. Now, they can agree to work with you to get caught up on this. The rent, I wish I had a judgment. Did you bring one?
I do.
That's okay. Yes, please. Sorry, go ahead.
Because the late fee is outrageous, too, $65 a late fee?
He reduced it by $100 and some dollars. I allow $40 a month, so the late fees were reduced. Good morning. And so that brought it down by $100 and some dollars. So through November, rent is $657. That's not that bad. Court costs are $198.
Wait, what'd you say rent was?
$657 through November.
No, my rent is 900 and.
No, the amount that's due,
Oh,
not
okay.
not a month's rent, it's just a part of the month.
Okay.
$198. So you made a big payment, and that's very helpful. So $657 plus $198.40 is $8. I'll add it myself. I can't read my own writing. $657 plus $198.40 is $855.40. Now, that's due theoretically within 10 days. 10 days from today is November 24th. Now, November 24th is the Monday before Thanksgiving. Probably nothing much is going to happen. But at some point, December is going to come and there'll be another month's rent due. Let me repeat this. They can agree to work with you to get caught up on the rent, but a partial payment will not prevent the writ of eviction. You have to pay the whole thing. And I'm not entering any money judgment. You also have 10 days to appeal this. My suggestion is you go in and talk to your manager about getting caught up on this. The pet fee in the lease controls what somebody might have told you verbally.
Yeah, like I want to dispute that because I've got messages and emails from her reassuring me that as long as it's ESA certified that I won't be charged a security deposit and I won't be charged rent every month because that's why I moved there.
Well, what's in the, you can take it up with the management, but what's in the lease is what controls here. And it shows they list your pet, a 63-pound mixed brown dog, and it says clearly $30 a month. All right, so Miss Eby, I suggest you go talk to the management about some plan to get caught up on this and ask about the issue with the dog. If you got something that you haven't presented here, maybe this could be altered. But right now, your rent is less than a month, $657. So it's partial rent for November plus the court costs. Hopefully you can get caught up and stay in your placement. All right, ma'am, you're good to go. All right, we've got iPhone here. What's your name, ma'am?
Christina Nichols.
Ms. Nichols, we were trying to get a hold of you.
I'm sorry. I don't know why I didn't get nothing from anybody. I mean, you might have called, but my phone is, the settings are set on, if I don't know the number, it doesn't even ring. I just got all these, because I have so many scam calls. So I just got all these missed calls all the time, and I'm sorry. It's my fault.
All right, well, let's talk about your case. This is Vista Point versus Nichols. Christina Nichols with a C. File number is 251890LT. Mr. John Bradshaw is here on behalf of Vista Meadows. We were here last time. Mr. Bradshaw, you were here, and Chrissy Collins, your manager, was here then, and she's here now. We determined through November, the rent was $4,040, $198.40 in court costs, for a total of $4,288.40. You agreed you were going to move and turn in your keys. Have you been able to do that?
Well, like I said, everything's packed. I just was having a hard time getting somebody to go get it because I'm not in the same state. So I do have a friend that said she could do it today. Like today was her day off. She said she could get right on it today and get it. It's all packed. It just needs taken out of there.
Well, you get 10 days to move before they do the eviction.
Okay. So how many days do I have left? Is that starting last Friday or today?
Starting today.
Okay, yeah.
Until November 24th.
Okay, and then as far as a forwarding address, can I give that to you guys now?
I don't want you to give it to me over the live feed. Everybody will know your address.
Oh, okay.
So you can call the management. You're supposed to give it in writing within 4 days of your moving. If I had access to the conference room, I think Judge Patterson's using that, I'd put you in there. But anyway, what state are you in?
South Dakota.
My, they have snow on the ground there yet?
We did, and it's all melted already. So it's been 50s all week.
Same as here. All right, you have until, I see your judgment, November 24th to vacate.
Okay.
Now, there's no money judgment here. They may come at some point in a civil case to try to collect on your unpaid rent. But this is simply a possession judgment. Partial payment will not prevent the writ of eviction. When you move, you need to turn in the keys and give your forwarding address in writing within 4 days.
Okay.
So, but by law, they can't take any action until 10 days from today. Now, if you get out sooner, that's great for them. They can clean the apartment and re-rent it. They've got a waiting list. They've got people ready and waiting to use your apartment, and now it's just sitting there with boxes in it.
Yeah.
So the sooner you get out, the sooner they can rent it.
The room is open.
All right, that's good to know. Thank you.
Okay.
All right, you have till the 24th also to appeal this.
Okay.
All right, thank
My
you.
next one's not till 9/10, so I'm gonna do some other.
Mr. Bradshaw's gonna go deal with some other matters, and all right, Ms. Nichols, best of luck to you.
Thank you.
She told me she's not sharing first.
All right, I got 3 people in the waiting room. Ms. Hines, why don't you come on up?
All right,
We'll see who we've got. We may need to advise this group of people of their rights. Each of those was a second hearing.
Thought it was easier to come in person.
Yes, it is sometimes. Or you have cases behind us or are you all
No,
done?
I'm all done with that contract.
All right, well, let's see who all we've got here. We've got David Misiak, who is our defendant in the next case. We've got a telephone number. Who's here by telephone?
Curtis Webb, sir.
What's your name?
Curtis Elias Webb.
All right. And we've got Mr. Havens and Miss Patinod here also. So for all of you, Mr. Misiak, can you hear me? Mr. Misiak, can you hear me? You logged in earlier, you were practicing, which I appreciate. I can see your name, but I can't see you and I can't hear you. Can you hear me? Mr. Misiak, you're our next case, so we need to bring you into the hearing. I lose a lot of time in my life doing this, but if we can get our rights done, we can tell 3 people all at once. Mr. Misiak. I'm going to remove him, see if he logs back in. I can't hear you and I can't see you. So it's like you're not here at all. Try to log in again. All right, he logged out, but now I can't start until he gets here. But Mr. Havens, Miss Patnott, I appreciate you being here early. Mr. Webb, I appreciate you being here early. If I could get our next guy in here, we could start. Don't you wish you were back there doing criminal pretrials?
No.
Doesn't miss it a bit.
I walked in today and thought, it's the last
Yeah, you
pretrial
saw
there,
it.
is it first or second Friday?
Well, it's the 3rd Friday, but he moved it because of the holiday. He logged in early, like at 7:15.
Well, he asked for an adjournment yesterday.
Yes. He said he would try to log in from his car. Mr. Webb, can you hear me?
Yes, sir.
All right, well, I'm going to go ahead and advise the Patnod and Haven defendants and Mr. Webb of their rights as a tenant, the landlord-tenant proceeding. You are a tenant in a landlord-tenant proceeding. In Mr. Webb's case, they're asking to pay the rent. In the case of Mr. Havens and Ms. Patnod, they're asking them to move out. In either case, you have a right to hire a lawyer. If you cannot afford one, a legal aid attorney may be available to help you, or you could seek other legal help. There is no court-appointed counsel for civil matters. You have a right to have the case heard here in St. Joseph County where the property is located. Here's Mr. Misiak again. Mr. Misiak, can you hear me? I tried to unmute him from my end. Mr. Miziak, can you hear me? All right, we're gonna just continue. All right, you have a right to demand a jury trial. If you want to have a jury trial, you must tell me, the court, at this first appearance, or be prepared to file a written demand within 5 days using the jury demand form and pay the $50 jury fee unless court waives it for your inability to pay it. If your landlord has asked you to be evicted from a residential property because you haven't paid rent, you may be able to get assistance from the Department of Health and Human Services, Community Action Agency, or Neighborhood Inc. Or if you're a veteran, you may be eligible for some veteran services. We sent that information to you with the original packet. You do not need a judgment against you to get help from the places listed above. A copy of the summons and complaint from your case are sufficient. You may be able to reach an agreement with the landlord by going through mediation. If both parties are interested in that, the court can help set that up. And finally, if you can reach an agreement with the landlord, the council could prepare what's known as a conditional order of dismissal, which would show as a landlord-tenant case on your record. Mr. Webb and Mr. and Mrs. Havens, or Mr. and Mrs. Havens, your lawyers aren't here yet because we're a little early. Mr. Miziak's lawyer is here. His plaintiff, his landlord's lawyer, Mr. Lugie, they're ready to go. So Mr. Miziak, you're here, and I'm going to proceed as though you can hear me. This is a termination of tenancy case. There is no lease that I was able to determine here. I think the plaintiff purchased this at a foreclosure sale. Ms. Hines, what's the status here?
There was no written rental agreement since fall of 2021. My client agreed to lease 20 acres of land for Mr. Musiak's 11. At that time, there was 11 head of cattle, Highland cattle. He's now failed to really take care of the cattle. He's failed to pay any rent. He's allowing my client to do everything, feed them, give them hay, do everything necessary. So there are now still cattle remaining. There's 3 bulls, 7 cows, and 4 calves, 14 total head of cattle. That's on my client's land that belonged to Mr. Musiak, and we want an order of eviction because he can't keep caring for them at his own expense.
I understand, but I'm not sure this is the right. So I'm going to evict his cows. What are you going to do with them?
I mean, I guess.
Turn them loose?
Well, he's Mr. Lugie has a plan for the cows.
What's the plan for the cows?
Yeah, the plan is to sell as many as we can as quick as possible.
All right, let's assume that he had a house full of furniture.
That's how I explained it to my client.
And you filed for a writ of eviction. You don't just automatically get to sell all of his furniture. You get to remove it from your property. But it doesn't give you the right to his personal property. So
we'd like Mr. Musiak to come take them.
Well, if I could get him to speak to me. Now, he is here. So the law requires that I continue this matter for 7 days. It's not a default, even though I can't hear him or see him. He is here. This order, Mr. Miziak and Mr. Lugie, the the law requires in a landlord-tenant case that you adjourn it 7 days, at least 7 days. It didn't used to be that way. But when COVID hit, all the rules changed. We started doing things remotely like this. And there were issues. The government justifiably didn't want a bunch of homeless people during a pandemic. So there became federal funding available to help people stay in their residences. And it slowed down. It took time to do all that. So the law requires now in all landlord tenant cases that we adjourn it at least 7 days. So we have to do everything twice. Then after 7 days, he would get 10 days to remove the property. So 7 days from today would be next Friday, November 21st. 10 days from that would be December 1st. Mr. Miziak, you need to get a plan to get your cattle off Mr. Lugie's land. We're going to continue this matter depending on Ms. Hines' availability. Let's take a look. How are you for the 21st?
Okay. And if Mr. Musiak could call me, I mean, I would appreciate a phone call to see if we can work something out. We've asked for supplemental damages, so that might require a future hearing.
Yes. Yes, he's now, this isn't great. There's no lease. It's a handshake deal, which makes supplemental damages difficult.
But we have a history of paying rent and providing things.
All right. So we would adjourn this.
What time on the 21st?
Boy, the day's full. How about 8:45?
That's fine.
All right, we're going to continue this to 8:45. Now here's somebody. Let's see who this is. Somebody else is here by telephone. Who am I speaking with?
Good morning, Your Honor. This is David Miziak. I apologize for the technical.
All right, Mr. Miziak, did you hear everything we just said?
Only about the last 2 minutes that I missed. Everything else I had heard.
All right, here's the deal. They allege you've got 3 bulls, 7 cows, and 4 calves on his property, which is located here in St. Joseph County on somewhere.
Buckhorn Road.
Buckhorn Road. I drive past this all the time. He wants you to come get your cows and bulls and calves off the property. They're also going to ask for some financial money damages. The law says we have to adjourn this matter at least 7 days. So we're going to continue this matter till next Friday, November 21st at 8:45. Do you have something to write with?
I do.
All right, I want you to write Ms. Hines' phone number down.
It's on the summons, Your Honor.
All right, it's on the summons. It's a Centerville. It's actually a Corey Lake number in Centerville, but do you see it?
I do.
All right, I want you to call her. You can call her this morning, and let's see if you guys can work out some plan for this. Then nobody will even have to come back. But at some point, he's going to ask for money damages, even though there's no written lease. He's claiming that you owe money for tending and feeding and caring for your cattle. But the main thing is these need to be dealt with. Now, maybe you'll just agree to let him sell the cattle and call it good. I don't know. But I want you to call Ms. Hines and discuss this with her. Lori, potentially I could put you in the conference room. You guys could talk about it right now.
That's fine.
Laura, would you open the conference room for me? I'm told that Judge Patterson was not using it. So unless I hear otherwise, the matter's continued to next Friday at 8:45. You're all here. Mr. and Mrs. Lukey are here. You're here. Ms. Hines is here. I'm going to put you in a room privately. Your phone number hopefully will go in there automatically. And you guys can discuss the options to getting this cattle off the land. Is that agreeable with you?
It is, Your Honor, but I want to point out one thing that in my last attempt to access the property, Mr. Luby called 911 and the state police responded and threatened me with trespassing. So I need to know that I will be safe as I work to resolve this issue with him.
All right, is that true? You called the cops when it came out there?
Yes, Your Honor.
Why?
There was an understanding he knew he wasn't supposed to be there without me being there. And
Well, that's not a tenancy. If he's a tenant, he can come and go. You don't have to be there.
He had to protect his own cattle, so.
No, this isn't a
Yes.
landlord-tenant case. This is something else.
Well, but
If
we
he's a
can make.
tenant, he's got the right to go on there whenever he needs to. And you can't call the police when he shows up. So let's see if you guys can come up with a solution. So I want you to go in what's called the Zoom room. You spelled it wrong, but and then we'll set up a breakout room. You guys can talk about it privately. Hopefully you can come up with an answer and we won't have to come back. But if we do, it will be next Friday morning at 8:45.
Very good. Thank you.
All right, thank you.
Thank you,
All
Your
right,
Honor.
Mr. Misery, stay with, hopefully we'll go into this automatically. Zoom room and the phone number. Why don't you folks come right up here and have a seat? Good morning, Ms. Haddad.
Good morning, Your Honor.
Right on this side. Mr. Webb, Mr. Bradshaw's caught next door, so I'm going to jump ahead one case. I'm going to call the case of Village Manor versus Mary Pattinaud and David Havens. Are you Mary Pattinaud?
Yes, sir.
And you're David Havens? Yes, sir. Of course, I know you both, but I need to identify your record. Ms. Haddad, could you join us, please?
Yes, Your Honor. Just a second.
Are you in another court?
I am. I'm in between. I'm in between courts, Your Honor. Let me just.
All right, I guess we'll wait for you to finish your other matter.
That's okay. We can call it, Judge.
All right, well, you sound like you're at the bottom of a well, and I can't see you. So, it could be better. But this is a termination of tenancy matter. Oh, you're in your car, okay. And they're asking you to move for a number of alleged lease violations which contained in a letter of September 19th. What's your position? Are you willing to move or do you wish to stay there?
Your Honor, as I very well know, they want us gone. We had a wonderful, great relationship with Village Manor and Lori Cousineau, and we've been there 5 years. But we can't fight it, so we do got to go. We've been looking. We have we're on waiting lists for numerous apartment buildings and stuff like that. But there's just nowhere to go right now. So I know this is by law. You're going to do us 7 days. We're hoping and praying for the best.
Well, All right, let's talk about that. The law does require that I adjourn this 7 days. And then you would get 10 additional days from that day to move. Normally, a legal aid attorney would be here with us, Meg Bauer. I think she's off starting today for a week or so. So there's no legal aid attorney. Normally one would be here. So you may have some defenses, I don't know. But if you get evicted from subsidized housing, it makes you ineligible to get into other subsidized housing. So what this case calls for would be some sort of a conditional order of dismissal, that you could work out some sort of an agreement with your landlord and the council to vacate. But what you're telling me, I hear every single day, I would move if I had somewhere to move to. And if legal aid was here, they could perhaps assist with this. This law firm does a lot of landlord tenant work all over the state, and they know what a conditional order of dismissal is. But you are right. The first step we do is adjourn this a week. And a number of things in the letter, including unauthorized tenants and some other things, would be violations of the lease. You could have a hearing on it, but ultimately, if they prevail, you're right, you'd have to move. And you're not unwilling to move, you just can't find somewhere to move to. How much is your rent?
$746.
All right, that's less than market rent, but you're gonna be hard pressed to find something for $746.
Yes.
There's a few things out there.
Things were great. It's just we had a neighbor issue, and it just got ugly the last year. And yeah, it was just a battle.
When Miss Cousineau left, and now she's somewhere else.
And it led to a lot of household tension between Mary and I, and it just got ugly, sir.
Well, I'm sorry to hear that. All right, Miss Haddad, does morning work better for your firm for next week?
Your Honor, we can make ourselves available whenever the court is scheduled.
All right, let's continue this to 10:15 on Friday, November 21st.
Your Honor, did I hear you correctly? Mrs. Cousineau is no longer with Village Manor?
I don't remember. She changed complexes. Maybe she went from a complex to Village Manor.
Okay, yeah, that's why she was Riverside.
All right, 11, 21, 25 at 10:15. Now, what I would suggest is you talk to your manager and discuss perhaps a conditional order of dismissal whereby you would agree to move by a certain date and they would agree to dismiss the case. At this point, they have not asked for money damages. They just want you to move. But if you do get evicted, it could make you very difficult to get in the next place.
Yes.
So my suggestion, you may also wish to call legal aid. They're not available today. We gave you their number.
Yes.
But it sounds like you're agreeable with moving. And if we can get a conditional order of dismissal, that can be discussed.
So when we want to avoid that eviction search, because like you said, it would be very difficult to find other housing if that was to take place. So it would come back in 7 days and then.
All right, then I would give you 10 days from that day to move out.
If we got out before those 10 days, we can avoid the eviction.
Potentially, yes.
And then
so that would be my suggestion. Now maybe this is Miss Cousineau. I jumped ahead of a case, so.
I like getting here early.
Mr. Bradshaw's in 2 rooms at once. Miss Haddad's in 2 courts at once, or 3 or 10, I don't know. Miss Haddad, where else are you appearing this morning?
36th District Court, Your Honor. I'm actually in the parking lot.
All right, which is a whole different world.
Yes, it sure is, Your Honor.
That's Detroit.
That's a euphemism. That's right. That's a euphemism, Your Honor.
All right. All right, we're going to continue this to November 21st at 10:15 a.m.
Your Honor, may I make a suggestion? I would,
Yes.
in the interim, I would suggest that the defendants reach out to Attorney Bouchard's office. And if they plan on vacating, then they just need to make sure they turn in their keys. Otherwise, the case does not get dismissed. And then, I mean, if they can ideally vacate before the next hearing, we'd be more than happy to dismiss the matter.
All right. Did you hear that? If you can vacate before the next hearing, which may be a lot to ask for doing in 1 week. But if you can vacate, when you do vacate, you need to turn in the keys and give your forwarding address in writing within 4 days. Now, the number of the law firm is on the summons. They're in Bingham Farms, 248-731-7810. It's right there on the front page.
Gotcha.
You reach out to them and discuss the terms, and if you can agree to vacate, they can agree to dismiss it. Ms. Kuzo, are you here?
Yes, I'm here.
All right. We started a little early. They said nice things about you, by the way.
Oh, nice.
Anyway, they're going to attempt to vacate in a timely manner and seek a conditional order of dismissal. So they may be contacting you. They're also going to be contacting the Bouchard Law Firm directly regarding that. So unless I hear otherwise, the matters continue to next Friday, November 21st at 10:15. You can talk to your manager, but preferably go directly to the law firm and discuss this with them. All right, thank you.
Thank you, Your Honor.
All right, good luck to you, sir. Mr. Webb, Mr. Fleeman was, or Mr. Bradshaw was here, then he was out. Ms. Haddad, good luck there in Detroit.
Thank you, Judge.
All right. All right. Thank you. Good luck to you. So we're waiting for Mr. Fleeman. We've got Stacy Ames present.